Members, we have a quorum. Can I remind members that this meeting will be recorded and ask members to note that mobile phones should be switched off as they interfere with the recording. Tablet devices should be switched to mute, which is FN and F8. I remind members to declare their interest as appropriate throughout the meeting. And can I remind members to keep their questions short and concise, with one question and appropriate supplementaries per member. We will go around again for further questions as time allows. I advise members that we will be commencing the informal, clause by clause, of the Reservoirs Bill today, and this will take approximately 2 hours to complete thereabouts. So declare the meeting open to the public. Agenda item number 1 is apologies. Do we have any apologies?
Declan McLean.
Okay, Declan McLean. Any other apologies? Okay. Agenda item number 2 is chairperson's business. I visited the reservoir in Randalstown last Wednesday, I think it was. Very, very good, very, very informative, and I'm glad I actually went because it was a very good, it was good to be there to actually see a structure, something we maybe haven't seen to date apart from the visit we had in Newton Ards. It was very, very good to see the slipway in operation, also the mound that is basically the compound, the reservoir, and then also a concrete wall that was put in many years ago by Rivers Agency. How the reservoir worked, basically what it fed downstream, and the lie of the land around the reservoir, and the size and scale of the reservoir, and the type of the formation of water that was in it. So it was very, very useful. We had the publicity people from the assembly there also taking visual and audio on it, so it will be of interest. I don't know if it's uploaded yet to the website or not.
No,
but
it won't be until after we finish.
It won't be till after this, but it was very, very useful and informative to go out and visit. That's about it. Members, any questions? Okay, moving on then. Agenda item number 3, minutes of the meeting 28th of April 2014. Can I refer members to the draft minutes of the meeting on pages 6 to 13? Are members content that the draft minutes are accurate? If so, I will sign.
Agreed.
Agreed?
Yep.
Pen is away. Okay, thank you, Elaine. Okay then, agenda item number 4 is matters arising. Can I refer members to the matters arising at pages 16 to 35 and then also to page 15, which is the suggested actions. Does any member want to bring up any specific issue, or are they happy to go as suggested?
Chairman, just in relation to the response from the retailers, I think the most significant letter is the one from ASDA, where they do not require the 4 farm residency requirement, or indeed the 20 or 30 day residency in a farm before slaughtering. The rest do seem to have some sort of qualifying criteria. The ASDA letter is very significant in my opinion.
Yes. Just to keep members fully informed, as we have written to the Minister asking that she maybe consider getting all the appropriate stakeholders around the table into a meeting to try and thrash this issue out. That's where we're at the present time, but we have had all the responses in from the supermarkets and then of course the grocery code adjudicator there. Any further comment?
Sorry, I'm having trouble making out what you're saying. Is that on the...
So on the residencies, on the 4 residents, the spec for the
movement of cattle?
Say again, sorry?
The movement of cattle?
Yes, the movement of cattle and the in and out of spec for the beef prices that the meat plants are bringing now to bear on the producers.
They're now going to do their own thing.
Who, sorry?
The meat plants are now doing their own thing.
They seem to be separating to that degree and bringing in at different various speeds. Oliver, yes. We had undertaken the right to all the supermarkets and the grocery code adjudicator on that issue, and we've had the responses.
What about Naimia, or is it Naimia?
We had
The
them.
beef?
Yeah, they were the ones that briefed us on it.
Okay.
Okay, members.
Thank you.
Members happy enough as suggested?
Chairman, just on item 4 of the correspondence, There's mention here of an EU memorandum 34803, a total of 7.1 million lost in Northern Ireland as a result of the new EU rule. Any explanation for what that is?
Yes, that's the committee looked at that a couple of 3 or 4 weeks ago, actually before Easter, more than that now, and that's it was a new EU rule applies to all the bodies across the EU, and that means if the money on cap is going to be breached, the ceiling on cap is going to be breached across the EU, they impose financial discipline on all of the member states, and Northern Ireland's share of that was what, 7.1 million?
So this is 7.1
million taken off
penalty because
financial discipline was breached across the whole of the
Okay.
EU.
Thanks, Donna.
Okay, members content then, suggested action, or action as suggested, sorry. Okay, members content? Okay, members, agenda item number 5 then is Reservoirs Bill, clause by clause, and consideration of amendments. Can I advise members that the next agenda item is a critical stage for the committee in respect of the Reservoirs Bill. This is the point where we finalise all the issues raised before formally voting as a committee. This is the last chance for you as members to air your opinions, concerns and thoughts, so it is extremely important that you try to remain in the room for this discussion as much as possible. If any member feels that the clause is contentious or gives cause for concern, they need to state what they don't like about it and what would be a solution if they have them. You will need to have the following documents open in front of you: the consideration of bill clauses matrix at pages 37 to 130 in our packs, and the reservoirs bill at pages 131 to 211. We have 2 meetings in which to complete the informal clause by clause process before moving into the formal clause by clause process. I will take each clause in turn. I will briefly explain the clause and draw your attention to the evidence we have gathered on the clause, to any subordinate legislation or regulation contained in the clause, and to any offence and related penalties associated with the clause. You must begin to consider if the subordinate legislation and the offence and the associated penalties are reasonable and appropriate. Regarding offences and penalties, members may also refer to the table in the bill pack at tab 10, which is basically, it contextualises all the offences and penalties all on the 1 or 2 pages. Rivers Agency officials are in the public gallery and they are available to come to the table if required. Rivers Agency has also provided a synopsis of the amendments that are being considered, and that has been tabled for members' information. Members may wish to take a few minutes now to read that and see if they consider that these amendments will address the concerns of the committee. We will have an opportunity to discuss these potential amendments at the appropriate clause in the bill. Okay, so we're looking at this piece here, members, which has been tabled today, and that's basically just the thoughts of Rivers Agency and the department on amendments being considered by them out of discussions with us, and also, of course, as they have sat and in on the sessions that we've had with other members. So I will give you time just to read this and go through this before we even start the clause by clause. Okay, members, now what we will do is, as we go, I'll ask first of all for any initial thoughts on these amendments being considered. Now, I know that might be hard without reading it with the bill to know exactly what clauses they're talking about. We will pick that up as we go through clause by clause. So there will be times when we will relate to this piece of paper and the amendments being considered as we go through the bill. Now again, these aren't concrete yet. We don't have them finalised. We don't have them in front of us. It's only consideration. So we must be mindful of that as we go through. I will ask for any comments at this stage, but first of all, can I just say that the very first one, clause 17(2), it reads, to take account of comments made by the Ard Committee that the term risk may not be the most appropriate. Whilst I agree with that risk isn't the most appropriate term, it is still, whilst it deals, that clause deals with, or that amendment being considered deals with the terminology, instead of high risk, it will be something else, either high impact or high consequence. There is a fundamental in there that by which if a reservoir manager invests in his reservoir and spends a lot of money making his reservoir safer, it will still be of high consequence or high impact if it was breached. But what that doesn't deal with is the fact that in all probability the breaching of that reservoir may well have lessened by the investment that that reservoir manager or owner has put in. So I think it is important that we are mindful of that as we go forward. It will change, that amendment will change the terminology. It will not amend the fundamental issue, and that is the unfairness around if a reservoir manager invests in his reservoir, his compound, and makes it to a safer standard, then they will still have the same burden of regulation as before they started. Are any other comments, members, before we go through clause by clause? Are members content then to go through as? Okay, if members are content with this approach, we will now begin. Part 1 of the bill deals with controlled reservoirs, registration and risk designation. Everyone happy enough? Again, the bill in front of them, the matrix within their packs of pages starts at 37. The bill itself is in the pack. We do have our bill pack, and then you've also got the matrix at tab 10, which is the offences, schedule of offences and penalties.
Tab 10.
Tab 10.
Right one.
Okay, thank you. Okay, clauses 1 to 5 deal with controlled reservoirs. Clause 1, controlled reservoirs. The bill provides a regulatory regime for reservoirs that will be known as controlled reservoirs. Controlled reservoir is a structure or area capable of holding 10,000 cubic metres or more of water. From the evidence taken, it would appear that changing the capacity of the reservoir to 15,000 or 25,000 cubic metres will make little impact. Can I seek comments from members? No comments from members? Can I just add that it's still not clear from what I can see that how do you measure? Whilst I recognise that the 10,000 to 15 to 25 won't make a massive impact on the number of reservoirs that are controlled, and they still also have a clause whereby they can bring in reservoirs of a smaller capacity. We still do not know how they will be able to measure the compound of water compared to a natural lake. and what would be there naturally. So that should be something for members to consider. No comments? No comments on clause 1? Okay. Clause 2. Structure or area which is to be treated as a controlled reservoir. Under this clause, certain structures or areas which individually are not a controlled reservoir under clause 1 will be regulated by the bill as if they were controlled reservoirs. There is a regulation in this clause. The regulations made under this provision will be subject to Assembly scrutiny under the affirmative procedure. And again, I'm going to ask the clerk just to explain affirmative procedure,
Oh, right.
if that's okay, Stella.
Yeah,
Sorry.
There we go. Sorry. Three assembly procedures for subordinate legislation. Negative resolution, rules made under negative resolution have the effect of becoming law as soon as they come into operation, and they can be annulled by the Assembly within the statutory period. And there's a technical way of accessing or calculating that. So for it to be annulled, a member or the committee must table a prayer of annulment, so that's negative. We'll come across that. The affirmative resolution is a statutory rule subject to affirmative procedure. It's made, printed and laid before the Assembly. It does not come into effect unless affirmed by the Assembly, and the Minister, normally the Minister responsible for the rule, will table a motion in the Business Office and the rule will be affirmed in the Assembly. So confirmative resolution, so the level of control, if you want to put it there, the level of oversight, level of scrutiny is a little bit higher on that one. Confirmatory resolution is a statutory rule which is subject to a confirmatory procedure, is printed, made and laid before the Assembly. So it's made and then it ceases to have effect unless approved by a resolution of the Assembly within a specified period, normally something like 6 months. And the Minister again will table a motion in the Business Office proposing that the rule be confirmed by the Assembly. So it's a little bit more freedom for the Department and the Minister in that one. So those are the three main types of statutory rules that will be referred to in the bill as we're going through.
Okay, thank you, Stella. Okay, so clause 2, structure of area which is to be treated as a controlled reservoir. Under this clause, certain structures or areas which individually are not a controlled reservoir under clause 1 will be regulated by the bill as if they were controlled reservoirs. There is a regulation in this clause. The regulation made under the provisions will be subject to Assembly scrutiny under the affirmative procedure. No issues have been identified with this clause. Can I seek comments from members? Okay, no comments. Clause 3, matters to be taken into account under clause 2(3). This clause requires the Department to take into account the probability and consequence of an uncontrolled release of water when making a structure or area a controlled reservoir by regulation under clause 2(3). No concerns have been raised via evidence from witnesses. There is a regulation which requires DARD at subsection 4 to consult with ICE, which is the Institute of Civil Engineers, and other such organisations if research indicates a need to consider additional matters. The regulations could amend the provisions in clause 3 of the bill. Therefore, it will be subject to Assembly scrutiny under the affirmative procedure. Can I seek comments from members? Okay, no comments. Clause 4, controlled reservoirs, further provisions. Subsection 1 allows the Department to substitute a different volume of water for the volume threshold of the reservoir. This is to allow the Department the power to specify a different threshold and respond to new evidence in respect of a reservoir. No concerns have been raised via evidence of the examiner of statutory rules. In order to be able to amend the primary legislation should the need arise, it will be subject to Assembly scrutiny under the affirmative procedure. Subsection 2 allows the Department by regulation to make provision about how a reservoir's capacity is calculated and how natural level and surrounding land are to be defined. Negative procedure is considered appropriate as subsection 3 deals with the consultation process in making the order and the regulations. Can I seek comments from members? Okay, clause 5, controlled reservoir supplementary. Subsection 1 details anything which is integral to the functioning or operation of a controlled reservoir. Subsection 2 details structures of areas which are not be taken into account in relation to what is treated as a controlled reservoir. Subsection 3 enables the Department by regulation to define with more precision the things that are listed in subsection 2 and to exclude other things from being or being treated as controlled reservoirs. No concerns have been raised in relation to this clause. Clause 5.3 will be subject to negative resolution procedure as it is felt that the Department will need the flexibility to amend the legislation if necessary. Can I seek comments from members? Okay, no comments. Clauses 6 to 8 deals with reservoir managers. This clause determines clause 6, reservoir manager. This clause determines who the reservoir manager is. It may be possible that there could be more than one manager. The committee received a number of comments from witnesses, particularly from fishing organisations and community groups, outlined at pages 42 to 46 of the matrix, alongside the response from Rivers Agency. Can I seek comments from members?
Right, Chair, are we at number 6?
Yes, sorry, clause 6, yes.
Can I just, number 8 there?
Sorry, say again, Oliver?
Number 8?
Clause 6.8.
Clause 6, 8, yep.
Yeah, sorry, 6.
Yep.
Who then is regarded as the reservoir manager under clause 6? Is it still the owner?
Is it still, sorry, who is regarded as the reservoir manager?
Yeah.
Yeah, well, there would be a reservoir manager, and then if they couldn't identify a reservoir manager, it goes on to the owner, as far as I know. Now, we have Rivers Agency here, if you want to ask that specific question of them. Yeah? If I'd ask you just to come to the table, David, every time, if that would be appropriate, please.
Yeah, we put this clause in because we didn't want there to be a grey area between the works that Rivers Agency does in terms of the free flow of water under the drainage order, that we wanted to make it clear that just because we maintained the water course to allow the free flow of water, that didn't mean that the department then became a reservoir manager. So by the removal of bushes or the removal of silt or some very, very minor maintenance type function on the water course, that didn't mean that we then become enjoined. We didn't own the structure, we don't have any responsibility for the structure, we didn't control water levels. So we recognise that as an issue, that people might be confused knowing that our diggers and our direct labour had been working on the water course, and whether that meant that we actually had some responsibility for the dam structure. So we felt that this was the best way of making it clear that, for the avoidance of doubt, if there was maintenance works carried on the water course historically, and it's still designated, so we will be doing that in the future, that didn't change the responsibility for the structure remained with, and the cascade of people in the top elements of that clause. So if there was a water undertaker, it was them, or sewage undertaker, it was them, or if it was some other business, or then the default position, then the owner, that we didn't take over responsibility because of the drainage order.
Okay, Oliver.
Fine.
Can I ask then, David, whilst you would go in and do work from time to time through your various guises and responsibilities and regulations, what would be the case then if, due to works that you completed, it's Rivers Agency, caused the structure to breach or prevented the reservoir manager from doing works that would stop it from breaching because of the works that you'd done? What's the legal aspect to that?
Yeah, well, I can't think of a situation where we would have done works that would cause it to breach, but I can think of situations where we have done works which have changed the flow pattern through the dam structure, and we know of a couple of those that we are actually examining ourselves to see whether that is more than maintenance. So, for instance, where there was a drainage scheme carried out, that there was, for instance, a spillway that was too small, and in order to reduce flood risk, that we have gone in and changed the spillway significantly. In a situation like that, we may well be a reservoir manager, and we know we have a list of a short number of those where we actually have done works, and we are examining those at the minute to see whether we actually have responsibility under the reservoir bill going forward. So this clause is really just in terms of the routine maintenance, not in terms of any capital works that we've done.
Right, okay.
I think that's a very relevant word there, the routine maintenance. You know, that, I think something like that needs to be built into that there, so there is no confusion when people read that we are talking about routine maintenance here.
Sorry, that's 6, clause 6.
Still the same one, clause 6, 8.
Maybe some clarification.
Yeah.
You know, something like that, so anybody reads that will know it's routine maintenance rather than you enlarging the waterway or anything got there. Because I take it if you do that there, you could then charge the owner of the reservoir if you have to do.
No, well, we wouldn't charge for that, because it would be part of a drainage scheme that we would have done for the greater good, and that scheme would have had to have an economic justification that was for the greater good, and we would have to be able to demonstrate that that was cost beneficial. So we don't recharge those the likes of those schemes back to the individual, but we have found a number of them where schemes have been done through what are impoundments, and we are asking the question, well, because of the works that we have done historically, does that mean that we actually are a reservoir manager, or what are the extent of our responsibilities? This will clear it up that in terms of carrying out or maintaining any works, that it's made clear to people that they aren't resolved of their responsibility. It doesn't automatically default to us in that case.
What happens if the work that you've done in the past led to either a holding back of water or increasing the capacity of a reservoir, to the point then that it has had a direct effect on inundation maps, which then has a direct effect on risk
Designation.
because of what you've done to either compound more water,
Yeah.
or prevent the running away of water?
Well, certainly, if there are any examples like that, we're certainly happy enough to talk to people to see whether the works that we've done made us a reservoir manager, or whether it was just purely maintenance or our routine functions that we were carrying out. I suppose what we're trying to do is tidy up what we've done in the past, because we didn't have this legislation to test what we were doing to see whether we became a reservoir manager, because this didn't exist. Obviously, we'll be wise to it going forward, now that each time we have a situation like that, we will be able to check it out before it happens. So that's why we know that there are a small number where we actually have carried out a drainage scheme, that we actually are asking ourselves, does that mean that we are a part reservoir manager because of what we have carried out in the past?
Would you have that detail at hand?
Not at hand, and again, we're down into very specific locations, but if there's others, if there are cases that you know of where works have been carried out by us, and there's a question as to whether we are a part manager, we're quite happy to do that on a case-by-case basis.
Even if you could furnish the committee with a letter of clarification, maybe on the points that Oliver and myself has raised.
Yeah.
And then if you can, at hand, get information on a number of reservoirs that may well be the case, that the works that you've done has increased the levels, maybe from a natural level, or further increased the level.
Yeah. I'm not sure we actually have any that increase it from a natural level, because the works that we tended to do
were on reservoirs.
Were on the reservoir, so there were pre-existing structures that we actually increased the flow through them. Certainly with that specific question, we're happy enough to look at the examples that we know to see if any of those fit that particular example.
Yes.
We're quite conscious that some of these, we're dealing with people on these just to try and work out who actually is the reservoir manager, so I'm not sure that I would just like the whole list to be published as is. We can certainly give you a number of examples if that would be helpful.
Okay, thank you very much. Any further questions for David before I relieve him from his post? On clause 6, we're not going to open it up and then our debate, but on clause 6. Okay, David, thank you very much. Sorry, you might end up jumping back and forth, but necessary evil. Okay, any further comments then on clause 6, which is the reservoir manager? Okay, moving forward then, clause 7, multiple reservoir managers, supplementary. This clause, clause 7, this clause applies where there is more than one reservoir manager. Subsection 2 provides that the requirements of the bill apply to each of the reservoir managers separately. Subsection 3 enables reservoir managers to nominate one of the managers to fulfil any requirements of the bill, with subsection 4 requiring details of the nomination, and subsection 5 requiring that the details are forwarded to the department or any qualified engineer commissioned in relation to the reservoir. Craig and Country Park raised an issue with this clause. It's page 46 of your matrix with regards to your pack, alongside the Rivers Agency's response. So it's clause 7, multiple reservoir managers, supplementary. Could I seek comments from the members?
Under clause 7.5, why do we wait 28 days after the date of nomination to give notice of the nomination?
Yeah, the nominating manager must not later than 28 days after the date of the nomination give notice of the nomination and of what it contains to the department B, each other reservoir manager of the controlled reservoir, and C, any supervising engineer, inspecting engineer, or other qualified engineer or construction engineer commissioned in relation to the reservoir, see parts 2 and 3.
I think that's reasonable.
What you're asking then,
Why 28
why
days?
28 days? Why wait 28 days?
Yeah, that's a month. And a possibility of another month after that there for any nomination is made, and the department may notify and consult the nominee in accordance with the nomination. You know, why a month, and then it could take another month? Why is it not done as soon as the nomination's made?
Yeah. But David, do you want to come again with regards to clause 7, with regards to the 28, 28 days?
Let David say that.
This little bit of flexibility was built in because we recognise that some of the reservoir managers will be clubs, and one of the people that engaged with us during the consultation with stakeholders before we actually started to draft the bill was just that they needed a little bit of flexibility, because what they needed to do was actually get approval from others before they were happy enough to release information. So there are a number of places where we have a little bit of flexibility, but without being too flexible that people then could use it as a loophole. So that's why the 28 days is there.
Yes.
Would there be any problem with 14 days?
Certainly, we have no issue with it, but I suspect the stakeholders may well think that it's a little bit tightening up, and I'm not sure that an additional 14 days of notification actually is really a benefit whenever we're managing these structures. What we intend to do, and this bill intends to do, is manage these structures forevermore. So gaining 14 days in terms of the long period of time that we're going to be managing these is neither here nor there. So I have no argument for or against it. You know, if you want it to be 14 days, I'm happy enough to make it to 14 days. I suspect it may well.
If I could, sorry, David, if I could pose a scenario, Oliver, if there was a council owned a reservoir, and there may well be procedures to follow within a committee whereby they go to a subcommittee and then to a full council meeting. That may well be a monthly cycle. There will be other occasions when there will be multiple reservoir managers, and an ultimate reservoir manager who will be responsible for gathering all the information. Some of it may not even be in their own gift, and it may come from other agencies like Water Service, our Rivers Agency, NI Water, and others like that. So it may be the case that they would need to have time in order to try and get that information. The agencies locate that information and then pass it back to the reservoir managers again on that specific time. You happy enough? Yeah. Any other comments then on clause 6? Oh, sorry, clause 7. Sorry for that confusion. Thank you, David. Clause 7. Any other comments? Okay. Clause 8. Duty of multiple reservoir managers to cooperate. This clause applies where there are two or more reservoir managers to cooperate with each other as far as is necessary to enable all the requirements of the bill to be complied with. There were no issues raised with this clause. There is no offence. Clause 8(2). Not to cooperate would be the offence. For high-level reservoirs, the penalty is a fine up to level 5. The scale for level 5 is currently £5,000. The second offence is for medium and low risk reservoir managers. It carries a penalty of up to level 4. The scale for level 4 is currently £2,500. So again, members, I'll refer to the offences and penalties table, which is at tab 10, of your bill pack, and then also the standard scale of fines on the very back page of that, and it gives you a context of the level of the scale and the amount of fine per scale. Any questions or comments on that? Clause 8. Could I maybe ask David, you are going to be up and down, David, but could I ask David then and Kieran, ably assisted by Kieran, I understand. Can I ask the question is why you specifically think that this scale is appropriate to that offence with regards to multiple reservoir managers who may not have it in their own destiny to garner and glean information, and then also whilst they might well be the most understanding person in the world, the other reservoir manager may not. How will this offence be, I suppose, proven, investigated, and then also then do you think that the scale of penalty is the correct one?
Okay.
I think that the first incidents like this will come to our attention via the reservoir manager. We imagine if he finds that other reservoir managers aren't assisting and him in the fulfilment of his duties, we imagine that's how this will come to our attention. We have taken, the department has taken legal advice on the level of penalties associated with any offence within the bill, and we've taken advice on this, and it has been advised that this level of penalty is commensurate with this level of offence.
Okay, any other comments or questions for David or Kieran? In the grand scheme of things, and with regards to the context of the whole bill and the other levels of penalty, this is basically apart from imprisonment, this is the top of the range. Can that be justified, given that it isn't actually a breach or something that would lead to a breach of a reservoir? It may indirectly, historically, lead to that, but this is just basically a failure to cooperate between maybe 2 to 3 to 4 people.
I think what we're trying to do here is encourage people to do what are quite straightforward duties. So cooperate, and it doesn't matter what the size of the penalty is, just do what is required here, and then we'll never get to that stage. So we want a penalty that means that people won't dawdle at this and won't necessarily play games with the legislation, with the department. What we want is these fundamentals just to be done. Tell us who's involved with this reservoir. Let's appoint somebody who's going to act on your behalf, and let's get the easy things done and dusted, and let's knowing that we will get to the more difficult things about works and about breaches, but try and get these easy things out of the way. And the penalty is there to encourage people not to dawdle at these early stages.
I think as well, sorry,
Yeah, go ahead.
that we will do our utmost to try and encourage the reservoir managers to work together. The Reservoirs Authority will do that. If we received a complaint that this wasn't working, that reservoir managers weren't cooperating, we would go out and talk to them. We'd try and encourage that. This would be a last resort. very much the last resort. As with any of the penalties within this, we would be trying to encourage as much working together as possible. It's only if, and I think I'm only maybe straying too far, but we would only seek to enforce if it brought the safety of the reservoir, into question. But it's there because we would want to use that as a deterrent against lack of cooperation, as the other penalties are.
Just remind us again, at this point, and whilst you maybe then move in to try and resolve the situation, what is it you're actually asking for at that specific time of the reservoir manager or managers?
Well, we're asking them to work together to agree, first of all, who the reservoir manager is, who will take responsibility for liaison with the Reservoirs Authority in connection with the reservoir, making sure that the requirements of the bill are met, that a supervision engineer is commissioned, that an inspecting engineer is commissioned at the appropriate times, that works that are expected to be done to the reservoir are undertaken. That kind of stuff. And for example, if there was works required to a part of the reservoir that weren't owned or the responsibility of the nominated reservoir manager and required the cooperation of someone else, of another reservoir manager, and they just weren't playing ball, and the question and the safety of that reservoir came into question as a result of that, that would be a rather serious issue. We would expect, though, that although we can't state this, that the reservoir manager who is nominated will be the one who is responsible for the important parts of the reservoir. But that may not be the case, and someone else may take on that responsibility. And if someone our reservoir manager who had responsibility for key, say the spillway, and wasn't cooperating with the nominated reservoir manager or any other reservoir manager, we would find that would be a quite serious issue, and would want to be able to stop that and to deter that as much as possible.
Okay. Tom, do you want to come?
Yeah, well, just listening to what you've outlined, and since there is a fine in place and everything here, are there then going to be a set of guidelines following this to clear up any ambiguity that might exist? Because listening to you, obviously, on this, it appears that could work into where there's some ambiguity about who should be doing what and what reporting they should be doing and all this type of thing. So will there be some type of guidelines on this issue that following the bill if it's passed?
I think we'd probably be leaving that as a matter between individuals to determine. We wouldn't like to be too prescriptive. Yeah. And we can see a situation where there may well be multiple managers, but many of them have little or no responsibility. So, for instance, I think we've used this example a couple of times. If you happen to be the landowner that is under the wetted bit of the reservoir, well, there's very little you can do that influences water level, and there's very little that you can do that really influences the safety of the dam structure, the impoundment, which is really what we're focused on, the safety of that, because that keeps the water in its place. We would be, rather than being too prescriptive, we'd be leaving that up to individuals to determine, well, I have little or no influence, and therefore I should carry little or no of the burden, and they agree that between themselves. But equally, as Kieran says, somebody that's a landowner there may well be an engineer, and may well actually say, I know I have little responsibility, but actually I'm going to, on behalf of this group, I'm going to take the lead on it, because I'm the best place actually to lead on this, because I understand engineering and understand the dam structure, and I understand it, and actually I can bring something more to the table than somebody that just happens to be a landowner that the dam structure actually sits on. So that's why we purposely tried not to be too prescriptive on that, but we're happy enough to provide informal advice. I'm not sure we can actually write down formal, strict guidelines or anything like that.
What happens if one of the people who are suspected or could be deemed as a reservoir manager, but maybe wouldn't have the ultimate responsibility for it, is a council or some other Crown agency? Is there an issue then with regards to Rivers Agency taking those, penalising those Crown agencies, taking them to court? There is this issue that can't take place at the present time.
No, there's no Crown immunity under the Reservoir Bill.
Right, okay.
So this does apply to the Crown as well, and you'll get to that at the very tail end of it, because we recognise that's one of the things we had to do is identify who the owners were and who the bill then had to apply to, and so it does apply to the Crown.
So say, for instance, if you own the reservoir, there's maybe a public road across it, or council owns part of it, and you've asked them to comply and give you information which is not forthcoming, then that still applies to them.
This still applies,
Yes.
yeah.
Right,
They have a duty on them to cooperate, and this duty, once it's at the start of the bill and it's laying out the stall, and what we said there was we want to try and get these easy things out of cooperation between two organisations or two people and sort of set that stall out early. This clause then applies through everything in the bill, and that they have a duty, that first agreement then should apply through all that they do. So if there is subsequently, for instance, works required, well then they still have a duty to comply or to cooperate with each other. And so I would really stress it would be very important to sit down and work out what your responsibility is for that dam structure and for the reservoir, and to negotiate that well with the other bodies. But you have to do it. The law is requiring you to reach agreement between those parties.
Okay, any further questions then on clause 8? Okay. Oliver, you're happy enough, yeah? Yeah.
I would go to 16.
Right, okay. Clauses 9 to 16 deals with the registration then. Clause 9, controlled reservoirs register. This clause requires the department to establish and maintain a register of controlled reservoirs. Subsection 2 allows the department to specify what information and documents are required to be contained within the register. Concerns were raised by fishing clubs, community groups and Creggan Country Park, page 48 of the matrix. The department needs to establish what information is currently available and appropriate for this register, and this will be done by regulations which are subject to negative resolution. The members feel that negative resolution is appropriate. Any comments, members?
I'm just going to 16.5.
No, sorry, we're at clause 9.
Sorry, right. I'm getting mixed up now.
Are you okay to wait then, Oliver?
I'll wait, yeah.
Again, just again, if we're going to ask Stella to remind us what negative resolution actually means.
Yeah. Negative resolution. Statutory rule made under negative resolution procedure have the effect of law as soon as they come into operation. As soon as the comes into operation date is reached, such statutory rules can be annulled by the Assembly within the statutory period. And for it to be annulled, a member or a committee must table a motion known as a prayer of annulment in the business office. So basically, a negative resolution would mean that normally it would come to the committee as an SL1, where the committee would agree the policy. It would come then as a stat rule, and then if the committee didn't agree with it at that stage, they would have to put a prayer of annulment down in the Assembly. And the committee have looked at that a couple of times. So,
Okay, our members, can I seek comments from members?
That's number 9.
9, sorry, 9, clause 9.
Can I ask on the clause 9, number 4? When we talked about Crown immunity, and the Secretary of State step in there.
Yeah, subsection 4 enables the Secretary of State to direct the department
Who
to
then?
withhold information on this.
Who then resumes responsibility for anything that is asked not to be registered?
Sorry, we can ask. Yeah, we can ask David and Kieran.
So this is not about allowing people not to register. This is about if there is some information that is in the interest of national security that the Secretary of State says do not release that information. I can give you a very real example. We have flood inundation maps that do not show depth and velocity. If we have maps that show depth and velocity, there's a DEFRA protocol from agreed in Whitehall that says depth and velocity, that's in the interest of national security, and you're not allowed to release that information to the public. It would be those types of things where somebody could misuse or use that information to do something that could cause a problem.
That's not a form of Crown immunity.
No, well, so the Crown would still have to register
Well, then who would be responsible for that?
Aye, but this is information
Yeah.
about any reservoir, not just the Crown ones. So,
Okay.
so if we had depth and velocity of any reservoir, whether it was public, private, an individual, company, whoever it happened to be, if we have that information, the Secretary of State would say that would be information that could be potentially used against in national security, and therefore do not release that information.
Then who's party to that information? As a reservoir managers?
The reservoir manager could be, but we wouldn't be putting it on the register, and the register is the public domain, would be in the public domain.
So Rivers Agency would see sight
Yes.
of that information.
We would have it because we generated it, and
Yes.
if we keep to this example, we could share it in a controlled way to the reservoir manager to allow them, for instance, to produce their flood plan. But that element, we would not be putting on the public register because of the sensitivity of it.
Right, so, but it's still, the likes of the planning service, would they be allowed to get sight of that?
The likes of planning service in terms of a development
Yeah.
application, you mean? Well, this is probably where we're getting caught up in the actual example that I've used, more so because we may well use a version of depth and velocity to show at risk areas. So if I think of a slightly different example then, so for instance, if we have a very, very large reservoir in the middle of a Belfast, and they say, well, we don't want that water release, we don't want any information surrounding that out to the public because people could use that against, to understand how that would be released and where it would be released. So it doesn't take away from the registration, it just means that the information surrounding that is sensitive. So for instance, the owner of it or who has keys for various things would not be made public because people could use that information for other purposes.
Okay.
Well, I can't see the benefit of that because if you have low, medium and high risk reservoirs, and I would take it the high risk reservoir would be part of this here.
Well, it may not necessarily be all of them.
Well, not all of them,
So,
but
so
some of them.
there are certain categories of infrastructure that, in terms of national security, are more important.
I think we need that more, not being disrespectful, but more explained because certainly it doesn't make sense.
Yeah.
No,
Definitely doesn't make sense. Taking it forward in that case.
I can understand it and grasp it. If the example you used, Oliver, if the planning service was concerned, they'd be writing to Rivers Agency anyway,
Yeah.
as consultees, who then could decide what information to give or give their opinion on the information that
Yeah.
they know.
That's
Yes.
right.
So it's not as if it would be hidden away and not used. It's just that in the public interest, it wouldn't be in a
How
public
would that-
register.
Well, I don't know. I can't see how that would affect national security.
Well, I think if you think of two reservoirs, exact same size, both in Belfast, one of which is used for public water supply and one of which is not used for public water supply, there would be a greater sensitivity and greater security around the one that was used for public water supply because somebody could go in and poison that, for instance, and knowing the man that has the keys to get access to that shouldn't really be put on the public record because somebody could then take that information and use that for wrong, as opposed to the reservoir, exact same size, exact same flood risk, but actually doesn't supply public water, and therefore there's a less national security issue surrounding that.
We could seek of Rivers Agency more clarification. in
Yeah,
written
if we
form.
could be exact that, but that could refer to anybody who had the keys of, a lot of places, with respect, it could pertain to anything. Okay, we can get more information on that.
Okay, any other further comments from members on clause 9 on the controlled reservoirs register? Okay, moving on then, clause 10, reservoir manager's duty to register with the department. This clause requires the reservoir managers of controlled reservoirs to register their reservoirs by providing the department with information and documents that are to be detailed in the regulations. The regulations requiring provision of information is not thought to be contentious and therefore negative procedure if considered appropriate. The committee did not receive any comments in relation to this clause. Can I seek comments from members? Okay, clause 11 then, structures or areas which are controlled reservoirs on the relevant date. Clause 11, this clause requires the reservoir manager to register a controlled reservoir not later than 6 months after the commencement date of clause 10 of the bill. The committee did not receive any comments in relation to this clause. Any thoughts on whether 6 months is appropriate? Can I seek comments from members? Is 6 months appropriate in order to register a controlled reservoir after the commencement date of clause 10 of the bill? Can I seek comments from members, if any? Okay, moving on. Clause 12. Structures or areas which become controlled reservoirs after the relevant date. This clause requires new controlled reservoirs to be registered within 28 days of the first issue of preliminary certificate. The committee did not receive any comments in relation to this clause. Can I seek comments from members? Okay, no comments. Clause 13. Structures or areas which are subject to regulations under section 2 in brackets 3. And that's section 2, subsection 3, that way you put that?
Yeah, section 2.3. Yeah.
Section 2.3. This clause deals with the registration time frame for structure of area which is to be treated as a controlled reservoir due to the regulations under clause 2.3. The committee did not receive any comments in relation to this clause. Can I seek comments from members? Okay. Moving on then. Clause 14. Fees, registration and administration. This clause enables the Department by regulations to introduce the requirement for setting, charging, collection and recovery of fees from reservoir managers to recoup costs reasonably incurred by the Department in relation to registration and other functions of the Department in respect to the reservoirs register. Armagh and Antrim Fishing Clubs expressed concern that the word may really means will, and the regulations will be subject to negative procedure. So again, it would need a prayer of annulment at that point. Are there any comments or questions on that? I have a few questions, David and Kieran, maybe if in order. Just on this specific, and I know we always talk about cost recovery in government, but I suppose that the question is, why should Rivers Agency not bear the costs of registration, considering that reservoir managers may have to invest heavily in their reservoir with regards to capital works, and also then the burden of the regulations for inspections. Is this necessary that they then would be asked to fit the bill with regards to the cost of the government's regulations and requirements, which may not be, which they will have no gift with regards to efficiency? How much would this cost even? Have we any sort of costings as to how much this would cost, and then how that would be distributed among the reservoir managers or owners?
We don't intend to bring in fees for registration. What we're doing here is just making sure that we're writing a piece of primary legislation that allows us to charge a fee if the economic situation continues to change and government policy is for all cost recovery. So at this moment in time, we do not have a fee or do not have a plan for a registration fee. At this stage, I don't see this clause actually being used. It's just there in case it takes us some time to get this through, and government policy at the time this becomes live may well be that government charges for all its functions. It's not at this moment in time.
Right, okay. but you do not have any sort of initial work done on a cost of the registration or any other similar schemes within the Rivers Ainsworth Department that
And no, and the reason being is because we don't choose or don't wish to introduce fees. We want people to register their structures. We want people for us to understand the risk that they pose, and we do see this as potentially being an impediment to that. All we're doing in terms of the legislation is making sure that we don't have a gap in it, that at the point that this comes live, that this maybe isn't compliant with government policy, but at this moment in time we don't plan to bring it, so we don't know what the fee would be because we have no intentions of doing it, so it would be Newquay rework in our view.
But sure, there had been some in-house calculations as to how much it's going to cost the department then, or a bid to EFP.
Well, we know how much we have bid for to administer or to staff up a reservoir enforcement team, and we have a recurrent cost of about £200,000 a year.
200,000.
Now that's met within the current CSR. It will be part of it was a new bid within the current CSR. It will then become part of our baseline going into the next CSR. And at this moment in time, we have no reason to think that wouldn't be funded, or it wouldn't be a function that would be important enough to be funded out of any allocation that we get. But we don't know that. We're told that we continue to be in hard times, and the next CSR period, certainly on the resource side, there'll be a lot of demands for money, but would be relatively confident that we're okay as an agency if we're funded, that we will see this as a necessary function and one that we would fund.
Mm-hmm. How do you counter the argument with regards to the may well words? Is that just how would you get around that fear and perception?
Yeah, I think there was a fear from that particular individual and from his dealings with us, because I spoke to him afterwards and after he gave his evidence and tried to reassure him that, look, we don't plan to do that, and there was a suspicion that we had ulterior motives. I'm not sure how we convince somebody that we don't. We've said before we don't plan to bring fees forward. We're on record here saying that we don't plan to bring it forward. That may well change if government policy changes, but this moment in time, in this area, we don't plan to bring fees forward.
Okay, any further questions then to David or Kieran on the fees, registration and administration? Okay, happy enough? Okay, thank you. No further comments then from members on clause 14? Clause 15 then, registration supplementary. This clause 15, requires a person to notify the department within 28 days of the date that they cease to be a reservoir manager and provide the name of the new reservoir manager. The committee received no comments in relation to this clause. Clause 16 makes it an offence not to register. The offence carries a fine of up to £5,000 for high-risk reservoirs and up to £2,500 for low and medium risk reservoirs. Can I seek comments from members? Just another question, David and Kieran, I apologise for this. With regards to clause 15, a person has to notify the department within 28 days of the date that they cease to be a reservoir manager. Well, that's all well and good, but then provide the name of a new reservoir manager. That may not well be in their gift. If a reservoir manager was to retire or was to leave in bad terms of employment, or even deceased, how does that work? How can you put the onus and responsibility on the ex or the past reservoir manager, who may then have no responsibility or outworkings in regards to appointing a new reservoir manager, or who may not even simply know?
Yeah, I think what we were thinking of in this case was where a reservoir is actually transferred to somebody, and in the same way you say, I dispose of my car,
Used car, yeah.
And I sold it to this dealer, or I sold it privately to this individual, or I disposed of it. That's what was in our mind's eye. I suppose it's something that we can take back and just maybe have another look at that to see whether there are other situations which may not be the norm, and whether we're a little bit too tight in that one, so that's something we can take on board.
That may work because in a used car scenario, you can simply say you have got rid of the car, or you have you have scrapped the car, or you've sold the car on to Mr. A.
Yeah.
There may be need to be some sort of registration where you can actually put on a form. I do not know.
Yeah.
It's not applicable,
Yeah.
even.
Yeah.
I don't know how that would work in registration terms, and then how you would seek as a department to find out who the new reservoir manager is, and who would you hold responsible for that.
Yeah.
I suppose in much the same way that we're trying to find the names of unknown reservoirs currently, we would probably be in that situation. Be a bit of detective work, if nothing else, but we would. That scenario might arise. So I'm just wondering whether it's a matter of extending the time scale for that, or putting something more specific in around the, to cover the scenario that you're suggesting.
If someone has no knowledge of the new reservoir manager, or a decision taken on the committee which he is now not part of,
Yes.
it's going to be very hard even the time.
Yes, it wouldn't matter how long you had.
The onus and responsibility is no longer his.
Yeah.
Yes,
In all
that's the issue. Yeah.
So maybe I'll be just adding if known at the end of that,
Yeah.
or something. But we can have a wee look at that.
Yes.
And again, I suppose you wouldn't want somebody that didn't have the responsibility getting a slap with a 5,000 or £2.5 fine.
Yeah, that's the issue. It's about placing the onus on the outgoing reservoir manager to give us the name of the incoming reservoir manager. Is that the issue around
Yes.
the onus being placed on that
Onus
person?
being placed on the ex or past
Yes.
reservoir manager then to come
Yes.
up with the goods with regards to the new manager,
Right.
when he may not know or have no means of
Okay.
knowing.
Yeah.
Turn on the camera.
Yeah.
Okay. We can have a look at that.
With regards to deceased,
Well, it's decision, or as you say, if somebody fell out, if it was a club and somebody fell out and just walked away, well then the club corporate is the owner,
Yeah.
but they then have to appoint an individual then who would carry out
Yeah.
that duty. So there may well be something that we need to have a little look at. Yeah.
Yeah.
there wouldn't be any issues around probate, family members, or falling on somebody who had no inclination or even any sight of his or their work. You wouldn't want a family member, dependent.
I think so. If the family members, say, took over a farm, took on and the farm was, land was falling down onto the reservoir, that would be part of the reservoir. Now that person may decide that they don't want to take anything to do with the reservoir, and again, it's about nominating a reservoir manager in those circumstances. I imagine if his father, for example, was a reservoir manager and the person who inherited the land didn't want to do that, he would have to go to the others and agree which other would take on that responsibility and let us know who that is. I'm thinking of that scenario. There may be others, but we'll have a look at that clause. I think the issue is about placing the onus on an outgoing reservoir manager to give us the name of the incoming reservoir manager.
Yeah.
Is a concern. There may be.
There is this grey area where some disaster happens within a family or an organisation. And whilst we can't always legislate for the worst case scenario, you understand there could be loopholes or even grey areas which would make it very, very difficult and hard.
Yes.
If there's been a family tragedy, the last thing on people's minds may be,
Aye.
this
To let us know.
reservoir.
Yeah.
Yeah.
Yes, to tell us who the new reservoir manager is. Yes.
Yeah,
We'll have a look at that.
You want to end?
I'm just thinking there what you're saying there about farming. That reservoir would be marked on the farm map. So therefore, if it did come to the son, it'd be the son's responsibility.
Yeah.
Yes.
But do you not have legislation within this bill here to appoint a manager, if need be? In the case of not knowing who the manager is, you can appoint one to oversee until you get a manager. Because
People are managers in law. So back to clause 6, these people are managers, and if there isn't a water undertaker, there isn't a sewage undertaker, or there isn't any other person that manages or operates it, well then it is the owner.
Yes.
And so it's not for us to appoint that cascade. There will always be one of those situations unless we get to a point where we have the orphaned reservoirs, and that's where then the department may need to step in
Yes.
in the interest of public safety.
Yes.
But there will be one of those, or somebody will own it. And so it's not for us to say you own that, therefore you are.
Yes.
Because you own that, you are. That's what the legislation is not
think-
burden on you.
I think, Chair, somewhere in that legislation, that line of succession of ownership needs to be explained there. That if a father does own the farm and that dam's on the farm, then it is the responsibility of whoever takes it over. Because it'll be on your farm map, has not been part of your farm, you know.
Yeah, it certainly is a grey area.
Yeah.
Yeah. Okay, now we look at it.
In terms of that, or 6, are we going back to reservoir manager? Is it that, or is it about the transfer of responsibility from one reservoir manager to another?
Yeah, I think about both. I think we've seen that. Yeah, because that may well need to be then tied up
Linked.
in another piece of the legislation.
Yeah, it links through.
We'll have a look at that.
Yes.
You know, again, if you're going to look at one clause, then you need to see how
link
that
that.
affects indirectly in other clauses.
Okay.
But it just seems to be a grey area or blind spot.
Okay.
Okay, any further comments then on clause 15, the registration supplementary? Clause 15. Okay. Clause 16 then is the offences registration. This clause provides that it is an offence for a reservoir manager to fail to comply with the specified requirements for the registration of a controlled reservoir and in relation to the change of reservoir manager. One comment was received from Armagh Angling Club, page 50 of our packs, which state that there would be no one in a fishing club who would be able to manage this requirement. There is an offence at subsection 2. The offence carries the penalty of a fine up to level 5, which is currently 5,000 for high risk reservoirs. The second offence for medium and low reservoirs, low risk reservoirs, carries a fine of a penalty of up to level 4. The scale of level 4 is again 2,500. You want it in on
Yeah,
16?
just on that there, on 16.5. You know, we talked earlier on there about the transfer ownership and who the next managers are coming in. On 16.5, we actually built in a defence here to a charge into the proceedings on the subsection that the person did not know and could not reasonably be expected to have known that the person was the reservoir manager. So on one hand we're arguing in the last one, and here we are, we're building in a defence to hit the person's argument, I didn't know. Sort of one contradicts the other there.
Very good, Oliver. I'm glad you were able to keep. I'm surprised you were able to keep your powder dry there as well. Discussion, but no, very good, very good. Commend you for that. You want to come up and could that same clause then be added in, if need be, added in on the face of the other clause, or is that necessary considering we already have it in?
These two are interrelated.
Yes.
I think in this, again, the way we tend to think through these is in actual scenarios. So if an estate was being willed to somebody who lived in America and nobody had contacted them and they had no reasonable way of knowing that they had become a reservoir manager, well then it's entirely reasonable, proper for them to be able to say, sorry, I couldn't have committed an offence because I had no possible way of knowing that I was this. So the two are related.
Yes, they are.
I suspect the person would use this clause as their defence then.
Yeah. He could say,
Yeah.
Daddy never told me.
Yeah. Well,
To work that through, actually, what we as a department would have done is charge him with that offence, and then he would have used that as his defence. And what has been suggested previously is that if we amend 15.2, it might take account of that, negate the need for that defence, because we would have never taken it in the first place.
Okay.
So that's the scenario that would have.
Okay.
Point well made.
Any other comments? Good man, Oliver. That's why you're here.
I'm useful.
Clauses 17 to 23 then deals with the risk designation. again, fundamental for this committee. These clauses, and particularly Clause 22, have caused some concern amongst the committee. Clause 17 then, given a risk designation. This clause deals with the requirement by the Department to give a risk designation as soon as reasonably practicable after the registration of a controlled reservoir. Subsection 2 establishes the risk designation as high, medium or low risk. There were a number of concerns raised in relation to this clause, particularly around the understanding of the word risk, and these are detailed at pages 50 and 54 of our matrix. Alongside the Rivers Agency response. Can I refer members to the tabled paper from Rivers Agency which indicates that it has considered some of the comments made by the committee that the term risk may not be appropriate and is considering an amendment to this clause. Can I see comments from members? Okay, if I could maybe speak with David and Kieran on this issue. And again, the amendments being considered by yourself, 17 clause 17.2, to take account of comments made by the Art Committee that the term risk may not be the most appropriate. You're right that the term risk may not be the right terminology. We are interested in public perception and alarming people and everything else, and you've said that, you've echoed that throughout the course of our scrutiny. So high risk, having something of high risk is not necessarily a good thing. But to change the terminology alone to something of high impact or high consequence won't change the fundamental designation that if you are high whatever, the burden, the regulatory burden will be placed on you, and no matter what you do, no matter how much you invest, no matter how much money you spend to improve the safety of your structure, you will still be left with with the burden of regulation that is deemed to be high risk, high impact, or high consequence. And there is no, to me, there's an unfairness there in that whilst you have a responsible owner who is prepared to invest in his reservoir, there is no real recognition or reward in the fact that he will still have to go to the minimum requirements. Now again, I know you'll say, but it doesn't have to go to the maximum requirements, so he will only have to do. But there does seem to be an unfairness there, especially when things can change downstream that will affect his designation, but yet he can't do, or she can't do, anything that changes his designation or their designation. Okay.
Can I jump you forward just to refer to another clause, to 22, 1B, that it does allow for whenever matters to be taken into account. It does talk about, in A, there are the potential adverse consequences, and B, the probability of such a release. So we have built it in on the face of the bill that we can take that into account. The issue still comes back to, as you heard from the Institution of Civil Engineers, that there is no agreed numerical way of coming up with the probability of failure. And so we have purposely built it in that if that is agreed, we will be able to take that in on the bill as written, but there is no agreed way in the United Kingdom of doing that, and that's our issue, of actually coming up with a system then that does determine the probability of release, because that's the probability of failure is technically nigh on impossible to in any sort of numerical way come up with a figure that says that's the probability of release. So it's going to be a difficult one for us to. I can't give an argument that wins this one because we've had this quite a number of times. Yeah. Clearly, you're not getting an argument that you're saying, right, that's it, set in my own mind. I'm not sure of anything else to give here other than to say it's built in within the bill. If the industry does get a way of numerically determining the probability of release. The bill can accommodate that, but it isn't there. We can't do it. The engineers came and said that they can't do that. So the best that we can do at this minute in time is accept that the probability, if they're all in reasonably good condition, the probability of reservoir failure is very low. And all we're then dealing with is what the consequence is. And that's where we've tried to say, if the consequence of it failing is very low, well then you're low impact or low consequence or low risk reservoir, and you will get the lightest touch in terms of regulation. If you have slightly more impact, well then there's slightly more requirements, and if you're in that top band, that top group, well then you're going to get the most regulation. And that's what we've tried to do, make a differentiation between the three. And the best that I can offer is just that we look at the minimum standards, as we've said under clause 25(2)(k), that we'll try and keep those minimum standards down to as low as possible. And again, that will give a differentiation between those structures which are in poor condition, and the engineer saying, look, I'm going to look at that every month because your structure's in poor condition, as opposed to the reservoir manager who then puts in the capital investment and gets it into good condition and then can look at it on the minimum standard. Unfortunately, that's the best I can offer at this moment in time.
So just to be clear, you're going to do something in clause, all right, what clause was it again?
So on the page, we said there was two things. So clause 17(2), which is the first comment on that, which is the one that you've picked up on just in terms of the terminology, because we do accept that living below something that is high risk, that terminology may well have a negative connotation to people below that. We're not saying that this is high risk, i.e. is at the point of failure. We're talking about a relative use of risk in relative terms. So here is a bunch of 150 reservoirs. These are the ones that we consider to be lowest consequence. These are the ones in the middle, and these are the ones in the higher group. Relative to each other, not in terms of relative to what we might consider to be risk of an airplane crashing or a car crash or food poisoning. Or these are relative risks, not absolute. So 17(2), and then 1, 2, 3, 4 down on that same page. Then clause 25(2)(k).
25.
That we will take into to take account of the comments made by the Art Committee.
Page 15.
In respect of the number of supervising engineers' visits.
Sorry, clause 25.
25(2).
K. 25(2). K.
Top of page 15.
Visit the reservoir where it is a high-risk reservoir at least twice. So you basically be...
We'll lower the minimum standard to as low as we're comfortable with, but without making it unattractive to the industry to not do it.
Is it possible to have some sort of certificate from an engineer where, whilst you have banded high, medium and high risk with regards to impact, is there any way where you could have subsections in the high risk, we'll use that term at the minute because it's on the bill, so within these high risk reservoirs, is there not a banding or subsection you can use where you can go high risk, probability low, medium and high? Now again, that wouldn't, I hear what you're saying with regards to the engineers haven't come up with a probability matrix or a calculation, but even in a ballpark, and if you come up with a subsection low, medium and high probability on a high risk structure, well then there could be differential minimum requirements for those subsections.
And you will have that situation, and it is built within the bill, maybe not just in the terms that you're using, because what you will have is you will have high-risk reservoirs which the engineer has identified works which are required in the interest of public safety. So you have that sort of those high-risk reservoirs which are clean, have a clean bill of health, and those high-risk reservoirs which the engineer is saying, no, you're not, don't have a clean bill of health, you have outstanding issues. And then you have a third step from that is us then taking enforcement against you as a result of these being identified. So you almost have that, whether it's just maybe as clear as it needs to be or whether we've articulated that as clear as it needs to be, but it's all high risk will not be the same under the bill because of what's identified in the inspector engineer's report. And then as a result of your action, whether we actually do anything about it. Now, whether that gives you that differentiation and whether we need to try and write that down some way.
Tom, you want to?
Yeah. Is it not the case that you could have a high-risk reservoir where a lot of work has been done on it to make it safe, as it's been looked at, and a lot of money has been spent and a lot of work has been done on, and that high-risk reservoir that remains high-risk is much safer than a medium-risk reservoir that no work has been done on?
Yeah.
And yet, no, you know, it's a lower risk than the one that's proven less risk, if you like.
Yeah. Well, the whole thrust of the bill is to require owners to bring all structures up to a reasonable condition so that the probability of failure of all of them is equal. And therefore, that's where the differentiation in risk terms is purely on the impact, because we're talking about the same thing. We're talking about the same matrix. But if you do all the works, whether it's high, medium or low, that levels the playing field in terms of the likelihood of failure. And therefore, all we are dealing with is the up and down axis of that matrix, whether your impact is high, medium or low. We don't want to allow structures to be maintained in a slightly worse condition because we're happy enough that there's not as many people live below it. I'm not sure we'd like to get to a situation or could see a situation where we could get to that. Although you could argue we're doing that for low, and that how a reservoir manager deals with their structure is basically a matter for themselves. And if they want to just ignore their structure, well, then that's a matter for themselves. But the only reason why we're comfortable with that is because there's nothing below it. You have to remember that the medium and high, there are things below it, there are people below it. The only difference is the speed of inundation and the depth of water. So the differentiator is whether somebody is actually going to die, not whether somebody's going to get impacted upon. Both high and medium, somebody is going to get wet. What makes it high is somebody may well get wet and die. You know, that's the differentiation that we have in it.
Oliver?
Yes, just on that argument. You have people down below it, could get wet, could die, whatever, but if you have a multinational coming in to do, for example, to do some construction, they could take a review, and on Tom's argument, could win that review and get something brought from high to medium.
Be the other way
Well,
around.
if you leave it open for review, then there must be that element of being able to do it. Otherwise, you wouldn't have the word review built into your thing. So
Yes.
the possibility of getting that downgraded is there.
So I was stuck on the term multinational and was trying to work out that. It wouldn't matter whether it was a multinational or what. We are quite happy for anybody, if they have different information or want to have the discussion with us or don't believe that this will kill people because they don't have the depth and velocity, well then we're quite happy for anybody to have that review, not just the multinational. But you are right.
Yeah, so what way does the review work?
The review of the risk designation. So we will give an initial risk designation which will be based on our flood inundation maps. The people may well come along and say, well, we've had somebody look at your flood inundation maps and we interpret it slightly differently. We can have that discussion. For instance, if they demonstrated that our basic topography, the shape of the ground, our assumptions were wrong, that actually somebody had come in and done something to the ground and the water actually went a different way, and therefore our predictive model was wrong. If they were able to provide us that information and demonstrate that with a good degree of certainty, well then we would accept that and change our designation through that review process. So we have no issue, irrespective of who it is, whether it's a multinational, a company, private individual. If they have information that's different, but we have actually, because in essence what the review is saying is we got it wrong. We're quite happy to change it. If we got it wrong and somebody shows us that we did get it wrong, we are quite happy to change our risk designation.
So the risk designation, a high, medium or low, really if it comes down to it, predicates on volume. Because I think as Thomas said earlier on, that you could do a lot of work on a high risk reservoir and it could end up more secure than a medium risk.
No.
So are we now down to volume?
Well, we're down to a number of things that will change between medium and high. So it's volume of water and the speed of inundation.
Yeah.
So if you have houses that we've seen at Kiltonga sitting right below the dam, anybody can work out that if in the event of that failing, there's going to be a wall of water will impact upon those houses. And I think everybody would accept that that would be a high consequence situation.
Yeah.
If we have a different situation where we have that same reservoir, same volume, but up in the hills somewhere, and the houses are 4 or 5 miles downstream. Now, our flood map still shows that they are caught within that, but it's going to take 20 minutes for that water to go down the hill to them. As it goes along the ground, the energy, that wall of water will have dissipated. That wall of water will have become a trickle of water, so they're still going to get wet. But the likelihood of that house being damaged or the people in it dying is clearly much, much less because of just the relative position of the dam and those houses. So it's not just the volume of water, it's what could be harmed, the relative location of that.
Okay.
With regards to your inundation maps at the minute, though, they don't show that.
That's correct. No. That's correct. We have undertaken that we will have depth and velocity maps. It's one of the work. What we have at the minute is a very coarse set of maps just to allow us to get what's the overall impact, and it was based on a number of assumptions. And even through the work that we have done, we have seen a number of quirks. So, for instance, and that's why I used the example of the topography. For instance, so one of the maps that we have looked at has a dead straight line of water, and it's actually trees. So the ground, the computer has worked out that there's a difference in level, and it knows that water doesn't jump steps, but it didn't know that these were trees. So we need to actually revisit the likes of those and make sure that that's permeable, that water goes in through trees, it doesn't just run down the edge of them. But that's what we get whenever we get a very coarse opening set of maps, and those will be refined into a much, much more detailed set of maps, which will then be able to give us depth and velocity and lots of other information.
So it is the case that some that may well have properties, an inundation map that has a house or a dwelling on a blue footprint.
Yeah.
Yeah.
It may be at that point that it is nothing more than a trickle.
That's
Yes.
correct.
And they then will become medium risk.
Yes.
They'll become medium,
Yes.
or we may well look at some of those whenever we get the more detailed maps and actually take those out, and they may, some of those, particularly if it's one house and it's at the very low end of an inundation, whenever we actually run the more sophisticated map, they may not end up in the blue area. Now, if there's dam and house directly below it, it doesn't matter how we change the flood inundation characteristics, it's going to be within a flood inundation zone. And the best you can hope for is it'll go from high to medium, but there may well be some where the houses are right at the extent of a flood inundation, that the more detailed maps may actually take some of those properties out whenever we get more detailed information on the ground profile or the location of those properties.
Okay, any other
Yeah,
comments?
what it does is it defeats your argument for someone in a high risk or who has a high risk reservoir. It defeats the argument for them to go and spend thousands of pounds on doing up and securing their reservoir. Because if you spend that money and you secure the reservoir, that reservoir is secure that it's not going to bust, or it's not going to leak,
Yeah.
or it's not going to send a flow of water down on top of people. If that money is spent and is spent and the construction is carried out by an engineer who knows their job, knows what they're doing, and everything's secure. That's secure
Yeah.
for another 100 years or more. That's not going to bust. It's almost leaving it sort of more or less impossible to bust in a sense.
Yeah. Well,
And yet it's defeating your argument to say, right, you spend this money, you do this up, but we're sorry, you're still high risk.
yeah. Well, you will not get, again, you will not get an engineer anywhere that will say, don't worry about that one ever again. You know, these are structures with huge forces, especially whenever you get into very, very deep, very high walls or very high embankments. The pressure on those are very, very considerable. What you will get is an engineer that says that you, Mr. Reservoir Manager, have taken all reasonable steps, that any of the obvious defects that we can do, we've tidied those up, that your spillway is the correct size to deal with extreme rainfall events, that won't take your dam away, and that you have a system in place to keep a an eye on it on a regular basis, just so we can catch any change at the earliest point. And if you have all those things in place, well, then your structure is as reasonably safe as we can make it. And that's really what the bill is trying to do, is trying to say that these things, it's not that they're not going to breach or that they're not going to fail, but that as many reasonable steps as can be taken are being taken. And that's whenever the enforcement then comes in. If those aren't being taken, well, then that's whenever we start to be concerned about them.
And we set in on a live risk designation process that's undergoing currently in England, colleagues in the Environment Agency, just to go through it, to hear and see what they do. And we posed the types of scenarios that have been posed through the evidence sessions here, and asked specifically about probability and about about reservoirs being improved and all of that. And while this doesn't expect it, I'm not expecting this to sort out the issue here, but and the Environment Agency don't take probability into account at all. And when they are looking at their risk designations, they have volume and speed and of water, and they're looking at, and they err on the side of caution every time. If there's any doubt whatsoever that somebody might be hurt, they will designate that reservoir as high risk. Now they don't have medium risk and low risk, so it's high risk or nothing or not high risk. So they don't have the same leeway perhaps that we do. But that's their position. They are on the side of caution, and if they think that there may be somebody be injured as a result of uncontrolled release of water from the reservoir, that's designated as high risk, and the associated management regime with that is introduced.
Okay, any other comments? We'll move on away from clause 17. Okay, thank you, Kieran and David. Clause 18 then, periodic reassessment of risk designations. This clause states that the Department must undertake a periodic reassessment of a controlled reservoir's risk designation, taking into account the matters mentioned in clause 22, and must either confirm or give the reservoir a different risk designation. The committee received a comment from the DOE, pages 55 to 56 of the matrix, along with the Rivers Agency's response. Can I seek comments from members? Okay, moving on then, clause 19, date on which risk designation given under section 17 or given as different designation under section 18 takes effect. This clause requires the notice given a risk designation for the first time under clause 17 or a notice giving a different designation under clause 18 takes effect on the day after the notice is served. The committee did not receive any comments in respect to this clause. Can I seek comments from members? Okay. Clause 20, review by Department of its decision in a review under section 17 or 18. This clause enables reservoir owners to apply for a review of the Department's decision on risk designations given by the Department under 17 or 18. The clause also allows the Department to commission a reservoirs panel engineer to provide expert opinion, which the Department is then required to consider when determining a review decision. The only comment that was received was from NI Water, who stated that the appeal system appeared to be strong and robust. Subsection 7 provides the power to make further provision in relation to applications and reviews of decisions on risk designation of a controlled reservoir. This will be subject to the negative resolution procedure. Can I seek comments from members? Okay.
On those, I take it then there's nothing in the department to claw back any.
Sorry, come this way first so I can hear you, Oliver, and then we'll bring the. Is that a question you seek off the?
Under that section, then any financial outgoings is borne by the department and can't be levied against the person who's asked for the review.
Yeah, I'm going to have to call the officials. Question. Okay, on clause 20 then. With regards to the review by Department of its decision under 17 and 18, who bears the cost, basically?
Yeah, well, we wanted to put in somewhere that there was basically a no cost or low cost review, so there'd be no charge for the department to hear it, and that it would just be the information, whatever cost to generate the information that the individual manager, they would have to just bear that themselves. But that would be a low cost because we were able to do it informally. So that's what the first review is, and then the appeal, obviously then that's ramping up and starts to be then a cost associated with that. But certainly the first review, we won't be recovering costs. We're happy enough to do that at no or low cost.
And the case of this having to go to court,
21-2.
you envisage going to county court or Crown Court?
20 doesn't go to court.
Won't go to court, it'll go to the Water Appeals Commission. It's the next clause.
Yeah, could I just ask then specifically, because it is about the cost and who bears the cost, if it's a review, as the one we're on at 20, or if we go to clause 21, it then looks at the appeal.
Yeah.
There is definite cost there,
Yes.
and it's for the
Water Appeals Commission to decide.
yeah.
Yeah. There is an issue around that clause, Chair. It's mentioned in your amendment, or the list that we gave, clause 21.9.
Uh-huh.
The issue there, so that you understand, and it relates to all of the other clauses where the Water Appeals Commission is mentioned in the bill. Currently, in the face of the bill, the department may make regulations with regard to what the Water Appeals Commission may or may not do. The Examiner of Statutory Rules has drawn the committee's attention to the fact that perhaps those regulations should be made by the Office of the First and Deputy First Minister as the oversight department for the Water Appeals Commission, in the same way as it does for the Planning Appeals Commission under the Planning Act. We are currently considering that. We've written to the department about that, and we are awaiting their response to that, and once we've received that, we will consider their response and come back to the committee on that issue. But that permeates the bill wherever the Water Appeals Commission, and it really was, the examiner's concern was that the department would be a party to the appeal, and therefore it needed to distance itself from that. We agree with that. It's whether OFM-DFM agrees with that. We're consulting on that.
Just very similar to the planning appeals.
It's exactly the same.
Where
yes.
You would go in and planning service would be a party. The applicant
yes.
would be the.
Yes.
Okay.
And I think for that reason that the Planning Appeals Commission was taken and given to under the auspices of OFM-DFM. I think our intention was that we wanted to make sure that the Water Appeals Commission could charge a fee and could award costs. We wanted to make sure, so we assumed that responsibility, but the Examiner of Statutory Rules has corrected us on that. So we're hoping that OFM-DFM will do that.
Yeah, with regards to Oliver's specific point about costs, I can't see it in the review.
No, there's no. That's why, because there is no cost in the review.
But in the appeals, I know we're jumping ahead.
Yeah.
But in the appeals, it
There
is
is a cost. Yeah.
9B.
9B.
Yeah.
The awarding of costs of the parties to an appeal, including provision in relation to the amount of costs.
Yeah.
The department may, by regulation, make provision. So what's that basically saying? The department will
We will
charge a fee for going to appeal, or
how it's currently written is that the department would make a regulation that would enable the Water Appeals Commission to award costs or to charge a fee.
right? Okay.
What the Examiner Statutory Rules says is the department, as a party to that appeal, shouldn't be in that position of making that regulation.
OFM-DFM.
Yes, so that clause and others will be amended if OFM-DFM agrees to read that the OFM-DFM will make regulations that will enable the Water Appeals Commission to do that.
Yeah. What if they don't agree?
Well, I think that
Chairman.
if they don't agree, I think that we're very keen that the Water Appeals Commission can do this.
Yeah.
For appeals against this bill. So we would have to think about that, but we would certainly try and encourage them in the first instance in order to comply with the Examiner Statutory Rules concerns. But if the Examiner Statutory Rules was able to set that aside in order to allow the Water Appeals Commission to be enabled to do that by our department, then we would be happy to do that.
But someone has to be in charge, and it shouldn't really be the department that may be a party to.
That's right.
No,
Yeah.
that's right.
The other option, we had considered a couple of other options for this, so we ended up with the water appeals. We had actually thought about the Institution of Civil Engineers because of the technical nature, and that the reservoir panel or the president could appoint somebody to hear an appeal. The issue with that wasn't because they're engineers and they're all part of this and throughout this bill and the engineers charter, but actually was because they couldn't give us a scale of fees. So the water appeals has a scale of fees, because the issue with not having a scale of fees is that could actually be a dissuading factor in somebody taking an appeal, because they don't know what they're entering into in order to try and win.
And how much it will cost them.
Whereas at least if they have a scale of fees on the Water Commission, they know this is what it's going to cost me. Win or lose, it's going to be at least that, and then they can take an informed decision about, is this worth taking an appeal? I've already had the review informally. I didn't win that. Am I prepared to take it to this next stage? And at least I know what the financial burden will be, or the financial penalty will be, or cost will be in terms of taking that forward. Whereas the institution couldn't give that, and that may well have been a off-putting to people, because they didn't know they were going to enter into an appeal not knowing where they would end up in terms of costs.
Okay, any other questions then on this? And then any other comments then on clause 20? Okay, thank you, David. I'm hearing clause 21 then, which we have been discussing. Appeal against department's decision in a review under section 2. This clause deals with the rights of a reservoir manager to appeal against the decision in a review of a risk designation given by the department. Subsection 9 makes the power for the department by regulations to determine the fee for such an appeal and the awarding of costs of the parties to an appeal, including the amount of costs. This will be a negative resolution procedure. The appeal is made to the Water Appeals Commission. Examiner Statute will advise that it might be preferable to consider conferring this power on the Office of the First Minister and Deputy First Minister, which has similar functions in respect to appeals to both the Water Appeals Commission and the Planning Appeals Commission for Northern Ireland under other broadly similar legislation. Rivers Agency has been asked to consider an amendment to this to confer the power on the Office of the First Minister and Deputy First Minister. This amendment would also impact or have consequential amendments at clauses 73.6, 74.2, 77.2, 79.7, 82.8, 84.6 and 86.4. Can I seek comments from members? It is one we've already just discussed. Okay, clause 22 then, matters to be taken into account under sections 17.3, 18.2, 23b 2 and 21ba. 21.5a, sorry. This clause is one which has given the committee considerable concern. It details the matter that must be taken into account in making a risk designation for the first time, in undertaking a periodic reassessment and in reviewing a risk designation. Concerns raised during the evidence sessions are detailed at pages 58 of the matrix. Alongside Rivers Agency response, the main concerns are that whilst the clause notes that probability and impact are part of the risk assessment, in reality the risk designation will be based on impact only. The Examiner of Statute Rules has suggested amendments to take account of the fact that there are two distinct rules when perhaps there should be one. Rivers Agency are considering this. Clause 22.3e and 22.4 are both subject to negative resolution. And again, we have basically discussed this with regards probability of such a release. It is in 22.1b. I think I'm reading that right. The probability of such a release. And again, there's no point going over old ground. There seems to be this issue with Rivers Agency not being able to calculate probability at this present time. Seek comments from members?
Chair, just maybe on further reading and maybe further thought, 22.2a4, cultural heritage, cultural heritage. What definition has the department applied to cultural heritage? Did we look to archaeology, potential sites? We could be looking to a reservoir there's absolutely nothing downstream of it, but somebody just said there might be something there.
Okay, David. Okay.
Sorry, that's just a straight lift from Floods Directive. So these are the 4 criteria on the EU Floods Directive. the way we interpreted cultural heritage in the PFRA, the preliminary flood risk assessment, where we had to assess the impact on cultural heritage, was on the built heritage predominantly. So, because it's hard to work out what the impact of our culture is of flood risk, so we had to take it as something that was actually tangible. So we in our assessment on the PFRA, we took it as built heritage. I suspect we would do the same on this, unless there was something of very, very significant heritage value. And we got that information on the PFRA from NIEA, from consulting with them. So the other items, human health or people, and economic activity, we were able to just do runs about where buildings were and where particular pieces of infrastructure was. And then on both the environment and on cultural heritage, we just consulted with NIEA to see whether there was anything additional that had to be brought into the assessment.
Mr. Chairman, does that mean, for example, a fort would be regarded as a cultural heritage?
Yeah, it was scheduled monuments in terms of the built environment, so yes, it could be.
What about moat or bailey?
Pardon?
What about moat or bailey?
Well, if it was a scheduled monument on the built environment, from the built environment section within NIEA, well then we may well, we would have taken that into account.
Chair, I'd maybe like to see a stronger definition.
Okay.
With regards to cultural heritage. Oliver, you wanted in?
Yes, human habitation. Would that not need to be in there?
Well, that's what human life is actually the term that's within the EU Extractive. And again, within the PFRA, what we did to assess the impact on human life was predominantly take where humans inhabit. And so that got dwelling houses, the data set was dwelling houses, and then the economic activity covered the workplace element of humans, and that's how we assess those through the PFRA. So again, the proxy of property is quite good to impact on human life.
Okay, can I ask, with regards to value of these four, human life, human health, environment, economic activity, culture, are they all the same? Are they all, do they all hold the same value with regards to designation?
No, they don't, and that was set out. We have an initial indication of how we would assess this in the public consultation document that we put out, and that set out where, again, where we tend to go back to the human life. So where there was one or more human lives likely to be killed, well then that got you in the high designation, and then the medium then was where there was impact on human life, but death was unlikely, and significant impact on the environment, cultural heritage, or economic activity. And then the low was where there was no long-term detrimental effect on, where there's no life likely to be impacted upon, and no long-term detrimental effect on the environment, cultural heritage, and economic activity. But we can provide that table again for you if you think that would be useful, just to clarify that.
Yes. Okay, any further comments then? On clause 22? Okay, thank you, David. Clause 23, high-risk reservoirs, medium-risk reservoir, low-risk reservoirs for the provision. This clause clarifies that the terms high, medium and low risk in relation to the controlled reservoir refer to the risk designation it has. A number of concerns were raised, and these are detailed on pages 25 to 29 of the matrix alongside the Rivers Agency response. Are there any comments, members? Okay, no further comment on that. Part 2 then deals with the requirements for high risk and medium risk reservoirs. Clauses 24 to 27 deals with supervision for supervising engineers. Clause 24, supervision requirements and commissioning of supervising engineers, etc. This clause requires a high or medium risk controlled reservoir to be under the supervision of a supervising engineer at all times, i.e. on an ongoing basis. A supervising engineer must be commissioned within 6 months of the risk designation taking effect, and the reservoir manager is required to give notice to the department within 28 days of the commissioning. A number of concerns were raised, including the lack of competition in respect of engineers and the availability of suitably qualified engineers here. There is an offence at clause 24.2 regarding commissioning a supervising engineer. The offence carries the penalty a fine up to level 5, which is currently 5,000 for high-risk reservoirs, and then the second offence for medium and low risk, it carries a fine of level 4, which is 2,500. There is an offence at clause 24.4 regarding notifying the department about commissioning and supervising engineer. The offence carries a penalty, again level 5, 5,000, and for medium and low risk, again scale level of 4, which is currently 2,500.
Sorry, just
Any comments? Sorry.
That gives the
Sorry, the clause is at clause 36, which gives the offence. Yeah, you have to go to clause 36 in order to come back then, clause 24. Are there any comments?
Can I ask a general question in relation to these engineers? Given those penalty fees that seem quite big, does there come professional liability cover as well for the reservoir manager in relation to any default by him or her in relation to the advice or otherwise that the engineer may give?
Okay, I'll maybe ask David to come up. I don't know if you got all that, David. Kieran? Do you want to go again, Joe?
Yeah, Chairman, in relation to these engineers that are relevant to this section, what is the function or otherwise of the professional liability insurance cover that would pertain to the advice or otherwise that would be given by him or her to the reservoir manager?
If in the event that the advice was shown to be negligent, well then there could be a claim taken against their professional indemnity insurance. So that situation would be blocked out by the bill and would be very real. But it isn't the case where the engineer then is proven to be negligent in carrying out their duty.
And would that engineer also have to notify Rivers Agency at the time that they would have completed an assessment of a particular reservoir?
What clauses are?
Yeah. I think it's 24.4. Oh, sorry.
Inspection report. It is covered, we just can't remember what the clause number is off the top of my head, we'll just check it here for you.
Yeah. Yeah, we can have that. Get that.
But the point can I just further query this? Yeah, the subsection 4 talks about a reservoir manager who commissions a supervising engineer in accordance with subsection 2 must, not later than 28 days after the commissioning, give notice of it to the department. So the onus is on the reservoir manager to pass the report to the department. Would it not make sense for the engineer to send a copy of his report also to the department so there would be no negligence by anybody?
Yeah, well, I think I wouldn't like to put that in just as a direct reporting line. The contractual responsibility is between the reservoir manager and the supervising engineer. Now, the situation may not happen, but let's assume that it could, that the reservoir manager didn't particularly like what it said in the report. At least then they could have that conversation under the contractual relationship they have, and the supervising engineer's duty or role would then be to convince the reservoir manager that what they have said was right and proper, and therefore the report then would be agreed and then sent to us. If coming straight to us with a recommendation, I would be concerned that conversation, that contractual conversation that would be right and proper to take place, may well be stymied somewhat, and we might have a report that a reservoir manager may not be content with, or that there may well need to be further discussion on.
The only point I would make, Chairman, is that given this has a wider public interest issue at stake, given that there's a fair bit of onus on the reservoir manager to carry out his duty subsequent to receiving the report from the engineer, I would have thought it would be relevant for the department also to get sight of the report of the engineer as and when he also sent it to the reservoir manager.
Okay.
The 25.3B covers that situation, but again, it gives you some time. So this is where we're saying what we wouldn't want is for the supervising engineer to sign it off and then for it to have to come straight to us. So in this case here, not later than 28 days after giving the written recommendation, we have to get a copy of it.
So
That's section 33.
play that in real terms then. So you hire a reservoir manager, employs a supervising engineer, they commissioning a reservoir supervisor
Supervising engineer,
to do the work.
Yeah.
He produces the report, which is given to the reservoir manager.
Yeah.
Then,
It's 28 days.
on receipt of that, the supervising engineer, on handing that over to the reservoir manager, he then, within, where did I see it, 33,
So they have up to 28 days before we get it.
where did I see it? I've lost it. Yeah, sorry. Yeah, no later than 28 days after giving the written recommendation, give the department a copy of it.
Yeah.
Yeah, if the supervising engineer considers at any time that the reservoir should be inspected in accordance with section 33, the engineer must. Now, what's section 33 saying?
33 is about inspecting engineers. So this is the 10 yearly inspection as
Yes.
opposed to the routine supervising.
Yes. But is that only then the 10-year? What about the 2 a year or the
That's what this is.
more critical?
Yeah, that's what this, the first bit that we're talking about. So, because the supervising engineer provides an annual statement. The annual statement says, here is the information from the reservoir manager about water levels, about the routine maintenance that they have carried out, and about the routine observations that they had, the walkovers to make sure that things aren't moving, and that all that record keeping. The supervising engineer then provides the annual statement, which then gives the reservoir manager assurance that everything seems okay, and then that assurance then is provided to us under 6 by 25(6).
Nearly at the bottom, page 15.
5(6). Supervising engineer must, not later than 28 days after giving a written statement under subsection 5, give the department a copy of the statement.
Yeah, so that's the annual statement. Now, we are currently looking at that as well, because if we go back to the discussion about what the minimum standard is, if the minimum standard isn't one a year, you can't give an annual statement, or can you? Do you just give a different sort of an annual statement? Can you give a desk-based assessment of the written records and the water levels and the routine maintenance, and whether that's sufficient, or whether for medium structures where we will potentially take it from the current one a year to less than one a year, whether as a consequence of that change we actually need to look at this as well for medium impact or medium risk structures. So again, that's caught up in the mix of some of the other changes that we're looking at the minute.
Okay. Joe, have enough?
Yeah, Chairman, it crystallises it and clarifies it.
Okay, any other comments then on clause 24? Okay, moving on then, clause 25, duties, etc. in relation to supervision. Some of these may well already have been covered then.
Yeah, we'll definitely be able to.
This clause sets out a key aspect of supervision by commissioned supervising engineers. Concerns raised are detailed at pages 65 of the matrix alongside the response from Rivers Agency. These concerns are outlined at pages 65 to 67 of the matrix alongside the response from Rivers Agency. One of the main concerns of the committee is clause 24(2)(k). Sorry, 25. Sorry, 25, yeah. 25(2)(k). This outlines the minimum number of visits by a supervising engineer for a high risk and medium risk reservoir. Members did feel this may be excessive, and Rivers Agency did indicate last week that they would consider an amendment to reduce the operational requirements. There is an offence at clause 25(8)(a) or (b) regarding giving copies of various reports to a supervising engineer. That's what we've just covered. The offence carries the penalty and fine up to level 5, which is currently 5,000 for high-risk reservoirs. The second offence for medium and low-risk reservoirs carries a penalty of up to 4. Level 4 scale for level 4 is, of course, currently 2,500. Are there any comments, members? Again, this is one that they have, Rivers Agency have looked at and are prepared, considering amendments to take account of comments from the Ard Committee in respect to a number of supervising engineers' visits to high risk and medium risk reservoirs. Again, this is 25.2K visit to reservoir, where it is a high risk reservoir at least twice in every 12 months period, where it is a medium risk reservoir at least once in every 12-month period. Any comments from members?
Just through
Yes,
the chair,
Oliver.
through the chair, when we go through all this, these supervisors' reports, we come down to high risk. Does the properties round that reservoir be notified of that category?
No, we can ask. I suspect.
Or should they be notified of that category?
We're now living in a house.
Again, this is another fundamental that the committee has looked at, and that is the burden of regulation and whether this is excessive. David, you want to answer the specific question from Oliver with regards to knowledge?
We wouldn't be writing out directly to all those people, but because we have a public register, if those people wanted to know, the information is available to them.
Right, and so they would be made aware of that register.
Well, there'll be a public register set out in the legislation. We're not going to write out to all those people and say that there's a register, but if somebody wanted to know if they were at risk, they'll be able to find that, and that will be information that's publicly available.
I know about Offer, but how would they know that?
Well, if you, in the same way that if you wanted to know if you were if you're buying a house and you were under the flight path of an airport, you could go and find that information if you knew that, right, I want to know about flight paths of airplanes, and I went to find, somebody will be able to tell me that information will be freely available. So if you know, right, I need to, one of my concerns is flood risk. I look at the various sources of flood risk. Am I within this flood inundation area? And I want to know not only just that I'm in a flood inundation area, but I want to know whether it's high, medium or low, or high and medium, because it won't, if I'm living in it, it will be high and medium. That the public register information is there, and they will be able to access that.
That'll be something that all solicitors would come back with in their search for property searches for potential buyers.
Well, I'm not sure, it's not a requirement of the legislation that solicitors must come back to it, but it would seem to be a very wise thing to include in searches.
Would they not be negligent by not coming back with that?
I couldn't possibly answer that question.
Yes, it's where I would like to know, because if we're talking about people getting wet and getting damaged, then if somebody's negligent in telling the potential buyer that you could get wet here or your house could float away, then there has to be somebody to take responsibility for that.
Certainly there's no requirement for the bill for the legal profession to include the requirements of this bill within any property search, but whether they do offer that, I'm not sure how they come up with the list of what's included in a standard property search. But there's certainly no requirements of the bill for them to do that, within the bill for them to do that.
That may be something we may or should maybe look at for protection of those people who live in that area. If there's no requirement for the legal profession to check that, leaves those people very exposed.
Well,
I'm keen to always keep the onus on Rivers Agency, Oliver, as opposed to the committee.
One thing that I would say, I would understand that if there was a negative issue, as I've said before, it is provided that reservoirs are kept in a reasonable condition, it is perfectly safe to live there. Absolutely perfectly safe. Our difficulty here at this moment in time is we cannot give assurance that all structures are in safe condition, and that's why we're bringing in this legislation, in order to require owners to get a professional to look at the structure, to carry out some rudimentary checks on it, and to keep them in reasonably good condition. And it is perfectly safe to live below a reservoir provided that somebody is managing it in a reasonable way. That's the thrust of this bill. So to then unnecessarily alarm people to say, well, here's something else to keep you up at night, if we get this in, they shouldn't be worrying about the reservoir above them unduly because of the requirements of this, and it shouldn't affect their household insurance, and it shouldn't affect their property values.
But can we give a guarantee that will not happen? Because if these insurance companies not find a loophole at all to put the prices up, they know this bill's been through. It's down really to River Agency now to be very robust within this bill here to state that fact.
Yeah, and we did, last time I give evidence that I spoke to the Association of British Insurers, and they give assurance that there is no issue with the bill. In fact, they're quite keen to see this come in because that gives them the assurance that the risk is low and that all we're dealing with is consequence, and they understand this risk, and therefore they are quite prepared to keep it as a standard part of household insurance, but I don't see that being withdrawn. That is the situation because the ABI represents the UK market, and that is the situation in England, Scotland and Wales, that there is no issue about living and getting insurance below a reservoir. It's not a material issue, and not one that we're aware of.
With regards to the actual detail of the clause and the parts thereof, with regards to the high risk reservoir, at least twice every 2 months or 12 months, and medium risk at least once every 2 months. I know you're considering amendments on that after talking and discussion with the committee. Can you shed any more light of where those amendments will lead us? Or
yeah, I think what we're going to do is we've had our thoughts within the department. We want to also then just double check our thoughts with the institution, because we said that there is if we push it too far, there may well be a consequence on actually getting engineers to carry out this work. But our thoughts for high risk is to take it down to 1 in a 12-month period. We're still undecided about how comfortable we are pushing it out on medium. It'll certainly go to an inspection every other year. Whether we're prepared as a minimum standard to push it out to once every 3 years, that's the discussion that we really want to have with the institution, because what we don't want to get this situation is where we actually, through legislation, develop a service that can't be delivered because of the risk and the professional indemnity that Joe mentioned earlier, that engineers just wouldn't bother touching it if they thought that all that was going to be paid for, or all that people were prepared to do or wanting to price on the basis of, was the absolute bare minimum as set out by the bill.
okay, any comments from members, even in light of what they just told us there with regards to reducing it from at least twice every 12 months to once every 12 months for the high risk reservoir? So it would basically be at least an annual inspection.
Seems reasonable.
Any comments or questions? Again, if I could put one thing in, and again, I suppose I compare it then to an annual MOT, where you have car, moving parts and everything else, and being driven every day, doing different things every day, travelling different distances every day. Maintenance would be surely higher, more of a burden on a car than it would be in a reservoir, I would imagine. But yet we equate an annual MOT car with an annual inspection of a reservoir, and I'm not 100% convinced that that is comparable.
Chairman, the only point I would make there is, in a very severe winter with a very high frost, sometimes concrete structures can be affected.
Yeah. Ian, you want to come in?
Thanks, Chair. The last meeting I remember, I think you made the point that these reservoirs have been in place quite a long time. Being inspected every year was just a wee bit too much, and I go along with that. That something that's low risk. What are we talking about? I'm sorry, I missed.
Sorry, this would be for high risk.
Yeah, but and low risk, medium risk. I know you say once, reduced from twice to once a year, right? That's fair enough, right? But for medium and low risk, surely you'd be talking there, in the terms of 5 years, because, like, I would imagine.
Well, sorry, low risk. Low risk is
Low risk is
nothing.
There's nothing
There's
at all,
no
right?
requirements
But
on
even
the bill.
medium risk, you know.
Medium risk at the minute is setting at least once every 12 months. High risk is setting at least twice every 12 months. Now, an engineer could come and say, no, you need to be inspected quarterly.
Yeah, I
Or,
understand.
you know,
Mr. Chairman.
Right, well-
Yeah, Mr. Chairman, but many of these reservoirs haven't been had any engineer looking at them for 50 years. Now all of a sudden we need twice a year. This seems way over the top in my eyes, but I'm not so sure. You know, for 50 years, no more, they've never been inspected or regulated, and then all of a sudden we need them twice a year.
Yeah, who comes up?
I'm not so sure that's totally necessary. But
Yeah, the point is, who comes up with the idea of a year or 2 years or 5 years, you know, and based on what?
Yeah. Well, I outlined the rationale the last time, and the reason why I'm comfortable going down to 1 per year is because that's, in essence, that's what the English, Scotland and Wales situation has been, and they've had their structures inspected on that basis since 1930. So there's a long period of evidence that says that, you know, that seems to be a reasonable level. That's balancing the cost of the individual owner and also the approach that the engineer wants to do, that they understand and know their structure. And so that's where I think that it is reasonable to change the twice in 12 months down to once in 12 months for a high risk or high impact structure. For medium, as I say, we're undecided. It'll certainly move from 1 and 1. If we're quite comfortable with every other year, we're going to have the discussion with the institution to see whether going out to 1 and 3 is acceptable. We just have that slight concern that we may well be writing it in the legislation and it have no effect, because the engineer says, I know what the legislation says, but in order for you to not overexpose my professional indemnity insurance, if you want me to do this, I'd need to look at it every year or every other year. Any less than that, I'm not touching it, and that may well be this. So we can push this out to whatever we want, but we're kidding ourselves that we're actually saving anybody any cost, because the engineers and their exposure and their professional indemnity insurance probably won't let them do this. So it's just balancing and putting in something here that actually is representative of what will happen in reality. But we accept that what as written is too high a standard. I think that we accept that.
Oliver, you wanted to?
Just very quickly, could it be that we're becoming more and more, to go through this bill here, at the mercy of the engineers? Everything we look at now, that's hypothetical, but it seems to be more and more that we are, and nowhere in this year do I see regulation of that engineers.
Yeah.
That's missing from in here, and that's becoming more and more apparent. And the other question would be, if a yearly inspection on a high risk every year, when can that high risk become medium?
Yeah.
It must at some stage become medium if you're doing it every year.
Yeah. Okay. The first element about the way engineers and the regulation of engineers, we have some elements of that in 106 where we will assess their reports, and we've also taken into the views of the committee that you would like costs also included in that, and we're looking to see how we will include that, not as a regulated activity, I must stress that again, but just as an oversight role that we may well have in that. I don't see a situation where this is just a charter for engineers, and I don't accept that. And the reason I don't accept that is because these are the professionals, these are the people that have been recommended, that their experience and knowledge is such that they can give this advice. The reservoir managers in the main do not have that same experience. They must buy it in. This is not something to be toyed with. This is not something that you can, that the layperson can nearly do okay and get away with it. This needs professionals to look at it. And so what we have tried to do in drafting the bill is make sure that the responsibility rests with the reservoir manager, but the assistance is clearly set out that an engineer and the services that they offer but without trying to give a charter or give too much for engineers. I feel that we've achieved that, and it's really a matter for the committee then to determine whether you almost agree with that or whether you'd like to push it harder. But I think there is balance in it.
Why I brought that through the chair was that the engineers are coming from a very small pot or pool of engineers, and that's coming from from themselves and their presentation. So whilst we're coming from a small pool, we're limited to our choices.
Yeah.
And as you said yourself, they will not go over their public indemnity.
Yeah.
So I think there has to be something, you need to look at something in there that does not allow the engineers to, in a way, dictate the pace of the bill.
Yeah.
There is a commitment to look at considering amendment clause 106.
Yes.
To take account of comments made by the Ard Committee that the Department should monitor charges being made by reservoir panel engineers and the over-engineering of reservoirs in Northern Ireland. Any other comments, members? Okay.
Just one final clarification. If in a situation we had a high-risk reservoir and there was an annual inspection, there was a recommendation that work should be done, and that remedial capital works were done, could the designation of this then change from high risk to medium or to low?
No, the designation doesn't change because the designation is predominantly based on impact because there's no agreed way of determining probability. So what changes is that is no longer a non-compliant high impact or high risk structure with outstanding matters in the interest of public safety and the consequence of enforcement being taken to get those issues resolved.
Thanks for the clarification, John.
Okay, any further comments? Okay, moving on then to clause 26. We will do clause 26 and 27, and then that leads us to a natural break, and I think that will do us today over 2 hours there. Clause 26, visual inspection directed under clause 25(4)(a). This clause states that the reservoir manager must comply with any direction in relation to visual inspection directed by the supervising engineer and requires the manager to maintain and provide written records to the supervising engineer on request and give notice to the supervising engineer and the department of anything identified during the visual inspection which might affect the safety of the reservoir. It is an offence not to comply with this clause at 26(1), 2, 2A and 2C. The offence and penalty are set out at clause 36. The same penalties apply as previously discussed. Level 5 high risk, level 4 medium and low risk. The committee did not receive any comments in relation to this clause. Can I seek comments from members? Okay. Moving on then to clause 27. Nominated representative under clause 25(7)(a). Further provision. This clause requires a nominated representative to be eligible to be commissioned as a supervising engineer and provides that a nominated representative has the same powers and obligations as supervising engineer when the supervising engineer is unavailable. The committee did not receive any comments in relation to this clause. Can I see comments from members? Okay, no comments then. Right, I'm going to leave it there, draw a line at that point, members. We'll pick this up again at clause 28. Can I just remind members that there is 120 clauses. That works out about another 10 hours scrutiny. It will mean an additional meeting. So just so the members are mindful of that. Can I just thank David and Kieran and the rest of the team. We were back up for you today. Very appreciative of you being here in attendance and answering our questions and jumping up and down when needed. So again, thank you very much for your attendance. Okay, members, we're going to park the reservoirs bill there and the scrutiny of it. For this week. What's that? Aye, well, we dedicated for it. Okay, bear with me a minute, members.
Page 35.
Okay, agenda item number 6 then is an update on single farm payments, 2013 payments and 2014 progress. Oral briefing. Now I refer members to the memo from the clerk at pages 213 and 214. Papers from the department, pages 215 to 216. And the Hansard of remote sensing and single farm payment session at pages 217 to 242. Can I welcome to the committee Andrew Elliott, Director of the EU Area-Based Schemes, Pauline Rooney, Head of EU Audit and Compliance Programme Unit, and Richard Crowe, Head of Countryside Management Unit. You're very welcome to the committee as always, no strangers to this committee. And the members have already had a chance to read your briefing papers, so can I ask you to take up to 10 minutes to address the committee? Can I ask members then to keep their questions concise and to the point, and supplementaries relevant to their initial question? We will go round again, members, if need be. So without further ado, Andrew, are you leading off?
Okay.
Okay, thank you.
Thank you, Mr. Chairman. I wanted to begin by saying that it's good to be able to come before the committee today, knowing that any of the farmers that we could pay this year have been paid. If we had come here in the state last year, the year before, indeed any other year, we wouldn't have had as many people with the money in their bank accounts as we have today. So that's kind of an encouraging backdrop to the meeting today. I do want to reiterate that 2013 was an extremely challenging year for the department in terms of the amount of change that was going on to our systems. And very large part that was due to the new LIPIS that we were putting in place to tackle the disallowance problem. That did have a major impact across a whole range of groups of staff, and it meant an awful lot of work as well on our inspection systems to make sure that they aligned with the mapping systems. So people did work extraordinarily hard in the department to try to get that as right as we possibly could get it. So in terms of the actual payments made, we had a good outcome overall, and the figures show that. We didn't slow up when we met our targets. We continued to work on as hard as we could to get as many farmers paid as we could, and that I think is an important thing to say. Because we do want to make sure as we go forward that we gain as much time each year that frees up time for the following year to allow us to do other things that come up that are often unexpected. In terms of the lessons learned this year, it wasn't perfect. We made mistakes. There were a couple of things that this committee drew to our attention, quite rightly. Farmers subject to inspection. In some cases, when we look back on the arrangements for that, we could see that there were ways in which we could have improved the handling of that, and so we wanted to say that to you. It was right to raise those issues, and it was right that we learn from them. In one particular area, we wanted to record that we went ahead with 2 zones for remote sensing when, with the benefit of hindsight, we realised that it would have spread the pain, as it were, of the slower payments more widely had we gone with 4 zones, and that's a decision which officials will want to be very careful about in future years. We also found that there was a very high level of field visits this year associated with remote sensing. We were careful to make sure that what we were doing was accurate and correct, and that required a lot of field visiting. We do think that the lesson from that perhaps is that we can scale down the amount of field visiting in 2014, because on many occasions when inspectors went out to the field, what they found was what had already been found. And so that's an important learning point for us. But we're still doing more detailed work on that, and we will want to report to you on that in due course. We need to ensure good communication with farmers, particularly when we're introducing them to a new kind of inspection regime, and we learned lessons about that as well. The best, of course, outcome of all is to make sure that we don't have to communicate with them because we have them ready for payment with all the other cases, and that really is one of the ambitions that we have for 2014. Finally, I want to say one of the learning points from this year that I think is important for farmers is that we found a significant number of claimants this year who took a risk and claimed in eligible areas. Many of those found themselves still in the system towards the end of the payment period. Those residual inspections contained a relatively large number who had claimed in eligible areas. And I think it's important to point out the risk that is on the part of those farmers who did that and didn't get identified in 2013, because with the new LIPIS in place and with the kind of control regime that we have now operating, even if they're not picked up in 1 year, there's a really good chance they'll be picked up in further checks later on, and with retrospection it will return to their claim in the 2013 year. So I really would like, if it's possible, to in engaging with farmers, to make sure that they take care to claim only the eligible areas, including where they recognise that the maximum eligible area recorded by the department needs to be amended or changed, because the cost of that is quite severe. And I have some figures that show probably about a third of an increase in the number of farmers who received no payment this year. So when I was last with the committee, we talked about the cash flow problems associated with a delayed inspection. But there are even more serious cash flow problems for those claimants who, because they didn't take care over their claim, found themselves with no payment at all in the year and no prospect of ever having one for that particular year. And we also had about a third of an increase so far, in terms of the figures we've collated so far, in farmers who received a penalty. So we really do want to work closely with the farming community, because we can make payments faster now with the systems that we have if farmers help us by being really careful not to claim the dense unmanaged rush, not to claim the scrub, not to claim the long unmanaged woody heather. Those are the kinds of terrains that really are getting farmers into trouble in terms of penalties. And we're very happy to work with people who are unsure about areas, talk to them, advise them as to what they should put on their claim. I wanted to say that now because it's not too late. The 15th of May hasn't yet passed. Even if a claim is already in, it can be amended at this stage. And indeed, if, probably the majority of farmers haven't made their claims yet, so there's still a chance for them to take that extra diligence that's so important in protecting their money. I think that's all I want to say at this point. Most of the rest of the information is in the paper.
Okay, thank you very much, Andrew, for being concise and quick in your opening statement. You certainly took only 6 minutes as opposed to the allocated 10, so I'm grateful for that. Thank you very much, and for your concise nature of your presentation. I suppose I go in straight into questions, and there's other members who have indicated here that they want to ask questions of the department. Again, there was a our draft corporate plan 2014-2015 considered here at the committee on the 1st of April. Within that, there is a new target being put down with regards to remote sensing, an additional business plan target 5.2, which states complete at least 500 claims for single farm payment in December 2014 that has been subject to remote sensing inspection. That's all well and good. Looks really reasonable and everything else, but what we don't know around that target is how many remote inspections the department will do this year. Last year was 1,139. How many you intend to do this year? When people will be notified, either through field inspections or by letter. You did talk about the fact that there was more field inspections through to the maybe nervousness around remote sensing. I'm really sure that the majority of them were done after December, if not all of them. So can those inspections be done well in advance of December in order to notify farmers and their businesses that they are actually under inspection regime. And also, what's very important geographically is the zones, where those zones will be. Will they be as concentrated this year? And you mentioned 4 zones. Where will these 4 zones be?
There will be 4 zones this year, but I can't tell you where the zones are going to be, unfortunately, because that would undermine the control. The Commission really wouldn't be happy if we announced where the zones were. But you'll be conscious that it's our desire to make sure that we move around the counties and make sure that there's that we can't always be checking in the one place. Having said that, we also have to allow for randomness, and there is a random part to the sample as well. In terms of the other points you make, one of the things that I have to say about the 2014 year, which it seems to be ever with us, is change, and we have a lot of change to manage this year. So one of the big changes that we're dealing with at the moment is the fact that we've received, we think, just over 11,000 trades. So in a normal year, we would have about, through the course of the whole 12 months, about 1,200, 1,300 trades. So it's a completely different league in terms of the amount of trading that we have to manage.
Repeat those figures again. You've had 11,000 trades in
over 11,000. We're still collating the final numbers, but it's over 11,000.
In a normal year, it would be? In
the normal year, it would be about 1,200, 1,300, that kind of territory.
Chairman, is that trades of entitlements?
Yes. Yeah.
So it's more than what's that work out in times? 10 times.
It's nearly 10 times. Yeah.
So
auctioneers are doing well, Chairman.
Well, you know, because you keep this keeps coming back that the gods are certainly against you, your department, Andrew, when it comes to, because every year there seems to be an excuse of more change.
No,
always out of your hands. Yeah. It's either a computer system. Yeah. Or it's now the trading of entitlements. When is the department going to get around these excuses and actually get down to the work and actually deliver for the people?
Yeah. No, just to be sure, it's not an excuse. It's something we anticipated more trades this year, and we're working hard on those trades.
But this time next year, it'll be an excuse.
Well, for example, we have already processed more trades than in an entire year last year. So we have actually we've got to work on them. One of the good things about being finished with the inspections is that it liberates staff to do other things. So there is a benign effect of actually catching up, so that in other words you can get on with all the changes, and the other changes that are coming in relatively large numbers are the number of business changes, mergers or whatever of businesses. There's quite a lot of work there as well, so that will be a challenge for us, but we intend to manage that challenge. So I wasn't sort of coming to you to say that, doom and gloom, it's going to be a bad year. We don't think that will be so, but I did think it was important to outline to you the risks that we have to manage. There is further development to systems. We're putting in place a whole new platform for our mapping system, which has to go into place this year to be in time for CAP reforms. That's a new thing called a corporate GIS. So that carries with it a certain amount of risk as well. So those are the things we have to manage on the challenge side. On the positive side, we've done a lot of the work of testing out and deploying the new LIPIS and the new remote sensing arrangements. So we would expect that to proceed faster this year, unless it's tripped up by some of the other things that are around. But we're optimistic, we're enthusiastic that we have a good, hard-working team who will make sure we manage through these challenges and achieve a good outcome this year. And I would be very keen to get as many of those remote sensing cases completed as possible before we have to make payments at all this year. The numbers you asked for, we haven't defined a final exact number, but we're anticipating it'll probably be in the range of about 1,600 remote sensing cases this year. There are some variables in the system this year in terms of the total number of business changes, and the number of businesses. There's quite a lot of work there as well. So that will be a challenge for us, but we intend to manage that challenge. So I wasn't sort of coming to you to say that, the numbers you asked for, we haven't defined a final exact number, but we're anticipating it'll probably be in the range of about 1,600 remote sensing cases this year. inspections we have to make and so on that we just don't know the answer to yet because of the amount of change that you can see is in the system in terms of the number of trades and so on. But that's our current plan. So a fairly hefty number of remote sensing cases this year and a fairly good indication that we'll be able to process them much more quickly than the year just passed.
But if, as you suggest, you do 1,600 farms by remote sensing, and you pay 500 of them before December, that's leaving approximately the same number of farms not paid this year through remote sensing. How is that justifiable?
Well, it's justifiable in that, one of the things we found this year was that we were still working on some remaining cases in April, and whilst that was better than ever before, it's not as good as we would like it to be next year. So our aim is to improve the pace with which we process all the inspection cases. So even if they're not all paid in December, we'd still like a very large number of them to be paid very quickly after December in the beginning of 2015.
And then just, and it was very unprofessional of me because my initial question I asked 5, but out of those 1,600 remote sensing inspections, how many, is there a target for how many you will have field inspected before December?
No, there isn't a target for that. We have to some extent, see, for example, depending on the zones we select and the kinds of habitat that we find, that will influence the amount of field inspection that's necessary. So, to give you one example, if we happen to find a lot of rush in the particular cases that we found, that might lead to more field inspection than if there was less rush.
Okay, Ian Milne.
Thank you, Chair. The stuff that I was going to cover was covered by the Chair's questions, but I say there, that the 2 areas that have been covered this year, surely they won't be 1 or 2 of those 4 next year.
We can't exclude that possibility from your thinking, but I would reiterate that we do want to ensure that as much of Northern Ireland is covered as we can possibly achieve over a number of years. So I can't really say much more than that.
Yeah.
Okay.
But it would be considered. Oh.
It certainly would be considered as an issue. Yeah.
Yeah, and I welcome the fact there that there are 4 regions now, or 4 areas rather than the 2, because a part of my area there was heavily concentrated upon itself, and there was a lot of complaints. But you said there, that there's more farmers not paid this year than ever before, because of irregularities within their applications, if you like, right? Yeah. So is that a result there of remote sensing?
No, it wouldn't be. No, we would have found this in the random sample as well as in the risk sample.
But then why would you have more this year,
Well, there was a new mapping, quite probably because of the newness of the mapping system.
Right.
And so, for example, one of the messages that we reiterated a lot when we were issuing the mapping system was that, there are certain areas that a photograph cannot pick up. It's important for the farmer to pick those up and remove them themselves, and perhaps that's a part of the cause of that. But it's something that we would see. We anticipated that something like that might happen, and we do envisage it going out of the system again relatively quickly, particularly as we continue to repeat the control system. So once you've got a good LIPIS and a good inspection process in place, these kinds of issues tend to not last for very long.
Just one final point, Chair, thanks. So those people there that won't be getting paid this year, so they'll be notified as to why, and will the farming community in some way be informed, in order to make sure that this doesn't happen to them?
Yeah, I mean, we certainly have guidance. For example, we put out compliance guidance to farmers on a regular basis. We try to communicate the messages to farmers associated with the key sources of risk, the kinds of things that cause farmers to get in trouble in this way. But it is something that we need to continue to work at, getting that message across. I think there are still too many claimants who think it's just a matter of ticking off whatever it is that's been pre-populated on your single application form, signing it and handing it in. and quite simply that's taking a risk. They really do need to be very active, either them or their agent, very active in checking that the fields are actually entirely eligible.
Thank you, Chair.
Okay, Robin Swan.
Thanks, Chair. Andrew, just to clarify, you said there was a lot of pain in 2 zones, and you're going to go to 4 zones. It's going to be the same number of farmers experience the same amount of pain, because they're going to have the same cash flow programs. If you can't guarantee your 500, there's going to be the same. It's still going to be concentrated in 4 areas rather than across the province. Am I right in saying you've Northern Ireland divided into 157 tiles, I think was the phrase?
Yes, that's correct.
So it will be 4 of those 157 will be remote sensing?
No, it would be, I think there, Richard, do you want to answer that?
Yeah, there are slightly more tiles. The tiles are really around the different ordnance survey type split. I think there's about 280 of those actually in total. But we will then take a number of those in each area, and those will be used. So it doesn't really divide equally in that way. But what we need to do in terms of choosing those zones is as the Commission requires, it's a random sample.
And does the zones have to specifically include a geographical area or a number of claimants?
It would tend to include a geographical area, which would then, we would have to ensure that there were enough claimants within that in order to carry out the control. Part of the reason why there are zones required by the Commission is that the member state or the region has to order up satellite imagery for that area. So therefore the satellite imagery is taken for those 4 zones. It's been taken at this point in time. So therefore it has to be in a concentrated zone, but it can be distributed in, for example, 4 zones around the region.
Okay. Thanks, Chair. And a supplementary, completely non-related, something like yours.
Go ahead.
Fine. Off today. The number of entitlements you were talking about, Andrew, you said increased from 1,200 to 11,000. That was the number. What's the actual volume of entitlement? Is that increased, or is it a larger trade and smaller entitlements?
Yeah, we don't have any more detail at the moment. It's because it literally just closed on the 2nd, so we still have to get some of the forms and so on gathered together and start to do an assessment of what's involved there. One of the most interesting things that we'd be wanting to find out is how many current claimants have decided to trade all their entitlements, because that then reduces your population of claimants, assuming they haven't made a claim as well. And we have some evidence that some people are making a claim as well as trading their entitlements, presumably with a view to withdrawing the claim at a certain point. But those are all, we have to do that analysis.
Okay, thanks, Chair.
I think a point to add, just to let you know, well, we have over 11,000 trades. You're getting more than 1 trade per farmer.
Yeah.
So, it'll reduce down to the number of farmers that actually have actually put trades in.
Okay. Good, next, Chair.
Could we have that detail in writing, could we? Obviously it'll take it
in due course, yeah.
In due course to get that organised, but that would be good, useful information to have. Yeah, William Owen.
Thank you, Mr. Chairman. And Andrew just touched on it there now. I mean, I have had some inactive farmers, some farmers who have sold their entitlements and are inactive, who are ringing me and say, do I need to put in my application again? So there's confusion. Some of those people don't fully understand that they don't put it in. And I do fear you'll have quite a number of those. That could clog the system up and could be problemsome later on.
Yeah, I mean, for us, it's better that they make sure they've traded properly and don't put in a claim. But I guess if they're in any doubt at all about whether or not their their trade might proceed, then they can cover their bases best by putting in a claim as well. But we couldn't encourage that. We just have to recognise that it happens.
If that situation arises, will you tell them there's no entitlements they can't claim? I mean, in the past, we were fully aware that many farmers, where there was duplications, and I declare an interest, I find myself in this position in the past too, whereby the department won't tell anyone who's in the wrong or who shouldn't have claimed, and then you understand.
Oh, well, that's where you're dealing with two different players. But
yeah, but that's going to be a similar scenario this year, because, I mean, if the non-active farmer puts in his claim, and the active farmer that bought his land probably taken puts in the claim too, there will be problems.
You could have a duplicate field, unless one of them withdraws. It would
Yeah,
be very
but one of them will have no indictments for Hester as well.
Yeah.
I mean, the thing doesn't, you know, I mean, but will you explain that to them? I mean, there's going to be a total clog up of the system if you don't.
Yes, we don't know. I mean, we don't know to what extent this has happened. It's anecdotal at this point.
But
but it is a risk we have to manage.
Yes, but I mean, the department needs to be prepared to deal with it properly and not let it linger on till you have a scenario back in November again where you have hundreds of farmers with duplicate fields and no one knows what's happened. You know, the farmers on the ground don't know. You know exactly what has happened, but many of those people have no entitlements and they can't claim. I think it's up to the department to explain that to them.
Yeah. And obviously, you know, a trading form gives a very clear indication as to what the intention had been in terms of the arrangement that was intended. So we will have to work through this. This is going to be, for that reason, a unique year. There'll be different kinds of issues that'll pop out of the woodwork in regard to this year. But we'll try and manage it as pragmatically as we possibly can. It's certainly from the department's point of view, valuable to get down to a situation where we have a smaller number of clearly active farmers participating in the system.
Can I just supplement to that? In relation to the large number of entitlement transfers, has the department a deadline when those will be transferred, or when do you expect those transactions all to be complete?
Do you want to?
Yeah, well, we're starting to work through it. I mean, the deadline was Friday.
Yeah.
2nd. So we need to see what volume there is, and we have additional resource working on that. We can't say at the minute how long it's going to be, but we'll get them finished as quickly as practical. But that could be some time. You know, it's 10 times the volume that we normally address. So we will get them done in time to make payments. But you know, at this stage, it's actually hard to say how long it will actually take, William. But it will be as quickly as we practically can do them. But that could be some time.
I can envisage some problems arising. I hope not. Okay.
It's only as you work through the detail, really, that you come across it.
Okay, Joe Byrne, Deputy Chairperson.
Thanks, Chairman. I welcome the presentation and I welcome the general sentiment that Andrew has intimated about lessons being learnt. I think that's worthwhile, in particular the fact about the zones and the fact that there'll be better communication with farmers. And I think that really is the crux of where we're going. As William has alluded to, if a difficulty arises about duplicate fields or claims, I think the sooner the department can alert the two people involved and it's quickly determined who is at fault, then I think the easier of resolving the situation. In relation to the corporate GIS, the new platform that you referred to, is that going to be interlinking with LIPIS, or what's the relationship there? Given that some of the farm advisory people have said that there has been an ongoing issue about 850 fields, this issue about where there's a concern that a farmer comes into the farm advisor, they advise him to get a map, they bring the map to him and it goes into the department and that map isn't matching and it's leading to a non-resolved matter.
Do you want to?
Yeah. In relation to the specific question about the corporate GIS framework and the LIPIS, the corporate GIS is an overall framework within which the LIPIS will sit. So in that sense,
it's the parent administrative system, is it?
Yes, it's the overall operating system in that sense. In terms of the individual LIPIS rules, then it won't have an implication for those. And for example, you mentioned the 850 numbers in that. In relation to the 850 numbers this year, we have stated out clearly that the 850 numbers were a mechanism that we used last year to alert farmers to the potential that there may be another claimant with a view on that land. But we've actually clarified that in our booklet this year to identify that farmers can use those numbers numbers, if they understand and they know that they are the sole claimant to that land, they can go forward and use those numbers just as a normal field number. So in that sense, whilst for example, the 850 was used last year to denote something, we've clarified that in our booklets this year, that again, where farmers know that they are the sole claimant, that they can go ahead and claim that land, but they have to make that decision on their own right.
But what about if the said 850 field happens to be a field of some dispute, whereas the active farmer that is the landowner is now making a claim on it, and the guy that has been renting it for some years is also making a claim? How quickly can we alert either or both parties to make sure that they can rectify the problem?
Well, again, we would be encouraging folks to resolve those issues in relation to before they put forward a claim. If a duplicate claim does arise, then that will be flagged up on our systems, and we would notify folk in the normal way as early as possible. But we would always be encouraging parties to resolve those issues within their own auspices.
It's one of those things where it's far better for the two claimants to be very proactive themselves than for the department to identify it, because once the department has identified it, then that's part of the control regime, and therefore one of the two parties is probably going to find themselves, having to pay penalties, for example, if it's a largish area. So it's better if we can get a message out in general terms to everybody that if there are two of you in the past who've been involved with this land, please make absolutely sure you've talked to each other, you know the situation, and that you've checked to make sure there's only one claim. And that'll be especially important in the context of anyone who's been trading. So that they should be live to it themselves or have their agents be live to the issue.
Thanks, John.
Okay. Tom Buchanan.
Yeah. One of the things that the farmers are always looking for is to get their money paid on time. What's the targets for the department for having a single farm payment paid by the 31st of December this year? What targets have the department got to ensure that it'll be paid out by then?
Well, we would hope we paid 90% last year in December. An awful lot depends on the nature of the quality of the material you get in, and where the errors are. But we would seek to try and try to get at least that this year if we can. We'll know better on a little bit further on in the year what quality of information we're dealing with and how much we have to go back to farmers to check that. And we will come out with performance targets. We generally do around about October time. The Minister did make a commitment this year that if we got 40% of applications in online, that she would seek to make more payments in December than we were able to do before, and that's a commitment that we will work to. I think we got 90% last year, so that would mean if we got more than 40% in, we would be seeking to go beyond 90% in December if we got 40%. The reason why that is we spend about 6 to 8 weeks every year after you get applications in, just taking the information from the paper application forms and transcribing into the computer system, because we can only really start to work with them and do analysis on them once they're actually in the computer system. So the more we have in online come in automatically, the less time we have to spend actually doing that piece of work, and the faster we can move on to actually doing the analysis that people are asking for, so we can figure out if there's duplicate fields and things. So
the computer system's up and running well this year compared to last year?
Well,
because there was a difficulty with it last year, isn't that right?
Well, we're always adjusting and making improvements to the computer system that we use. But the key will be how many we can get in online. Last year we had 20% online. If we can get to 40%, that will double the number that we got in, and that will give us a real head start in terms of how quickly we can start to do analysis of the applications.
Yeah, just one other question, Chair. What about last year's single farm payments? Are they all paid out by now, or are there still some outstanding?
As I said at the start in the introduction, there's 99% or more now paid. In any other year, if I'd been in front of you at this time of the year, I couldn't have said all the inspection cases were paid, because they wouldn't have been. They are this year, and indeed at this stage I don't envisage there are any farmers who had an inspection who haven't also by now had their payment received into their bank account if they're due a payment. I say the only message that I think qualifies that is to say we did have a fairly hefty number of farmers this year who received no payment because of penalties, and that's simply because they took too many chances in claiming fields that weren't judged to be eligible. And we need to make sure that we get that out of the system. Both it's in the interests of the farmers themselves as we catch up with them, but it's also in the interests of the department because it keeps risk to the fund down and it keeps disallowance down.
Just another one issue, I know that Bill's gone. There seems to be quite a delay in the appeal mechanism. What's been done to speed that up?
Well, the good news is we have speeded up the review of decisions quite a lot. We measure it in terms of total calendar days. That includes time when the appeals are back with the farmers themselves. So it's something we're continuing to work at. It is getting better.
We're going to have to suspend there briefly for this vote. We will have to, but if you could just hold on, there's a number of other questioners, and then I want to follow up to some questions too. So forgive me, but if you can just hang on for us.
Assembly.
I honestly don't remember.
Okay.
Can't be that long.
Okay. Thank you very much for your patience, Andrew, Richard, and Pauline. Thank you very much for hanging about. Again, Tom, I'm not sure if Tom was finished, but if he comes in, we'll certainly get him. If he wants to come in, I will let him in. Can I take us back to remote sensing? Can I ask the question, why was remote sensing brought in the first place? What was the rationale for remote sensing?
The rationale for remote sensing is that it has the potential to accelerate the pace of payments. So, for example, in 2013, which is the year just passed, notwithstanding the fact that we were challenged in terms of getting the system to work quickly, it was still faster than what would have been the situation had we had to do all of the inspections in the classical manner. Yeah. So it has efficiencies within it that allow us then, if we're doing a lot of development work, for example, as we are at the moment, to save time later on and to ensure farmers are still paid in a reasonably timely manner.
Mm-hmm. But this year, it's pretty clear to see that the 1,139 farms that were remote sensing inspected, in order for you to meet the target, what had to happen was basically they had to be, and I don't mean this in a flippant way, but they had to basically be set to one side in order for you then to go on ahead and meet that target. And the target last year was 90%. Is that right?
The target was 85%.
85%.
Right. We delivered 90%. That's why you have the 90% figure in your head, probably.
So you've delivered 90%.
Yeah.
Right. So next year, or for this year's cycle, if you like, your new target is 90%, which you have already achieved. But you're increasing remote sensing inspections from 1,139 to 1,600, 1,600. And you're going to deliver 500 of those in December. Where is the benefit? Where is the benefit for the system for remote sensing so many farms? In our way of putting it, why do you just not go to the same level of remote sensing as you did last year and meet the 500 target? And that way you will have increased your percentage, particularly for remote sensing farms. Because at the minute, if you're a farmer and you want to be in a classical inspection because there's a 90% chance you will be paid about that. But if you're a remote sensored, you're only a 30% chance of being paid.
I think the best way to put this is to say that what we're doing in the area in which I work at the present time is absolutely trying to pay farmers and pay them faster, but it's far more than that. So we've had to introduce major reform of the systems that we operate. And what that means in practical terms, for example, is that we put in place a new mapping system, and that creates certain uncertainties about what we're finding on the ground. We need to deploy our inspector resources increasingly carefully to tackle that risk, tackle that error, go out and check things that are uncertain, and we need to be able to use them as wisely as we possibly can, not just to manage the inspection control, but also to manage the mapping control. And so Richard and his team are able to use their inspectors across a much wider range of areas because we have this assistance coming in the form of the satellite photography and the ability to do more of a desk exercise on some of the inspections. So the aim over time is to move to a system whereby what you do on the ground is the stuff that needs to be done on the ground, and what you do at the desk is the simple, straightforward stuff where a photograph, an orthophotograph combined with a satellite image can provide you with really good, clear evidence. Once we get through the period that we're going through of change, major change, and there's a lot of change, of course, also associated with CAP reform coming through, then after that is over, you should begin to see other savings coming through from having deployed remote sensing, because it actually is a more cost-effective technique. But the reason we're not seeing those right away and all the benefits right away is simply because of the scale of change that we've had to implement. You've got to remember we have an EU audit compliance programme which has been costed at just under £50 million. That's a lot of change to introduce to a system like ours, and we had to do that to combat the disallowance risk.
So why not go safe and take smaller steps and do the 1,139 farms that you done last year and improve on that? Because it's bound to be more efficient than you taking another chunk off which you cannot chew like happened last year. How can you demonstrate that the 5% that you excelled to target last year was down to remote sensing, whenever those remote sensing, all of them, was basically left to one side and dealt with after December?
They weren't left to one side at any stage. There was a lot of work that had to be done to make sure the systems operated properly, but it really isn't good. It's not my way of seeing what we did last year was that we left any cases aside. It's important to remember that there were still other classic cases that were not completed until very near the end as well. You're absolutely right to say there was a big share of remote sensing at the end, and also you'd be right to say that we didn't initially expect that it would take as long as it actually did. It took a bit longer than expected. But even though it took longer than expected, in other words, even though we got a pessimistic outcome, in terms of the performance of the system, it was still faster than the classics would have taken a lot longer. We weren't able to commence our inspections in 2013 until, what month was it, Richard? It was quite late compared to other years, and we knew that that was going to be the case because of the systems that we had to build, and that was why we needed the remote sensing. It would have been a major risk for us not to have accelerated the remote sensing. And there are, as I described earlier, there are risks in the system this year as well. There are things we have to manage, and we know that the remote sensing will work. We're becoming more used to it. We know it'll work more effectively this year, so we have to trust in that and work through and see this programme through to completion.
Yeah, but no matter what you do, your outcome, if you hit these targets, your outcome will leave the same amount of farmers as this year that were remote censored inspected who haven't been paid.
Well, you're looking only at one target, which is you're looking only at 1 month, which is December. So, for example, if we achieve 90% in December and we then achieve a higher outcome in January and in February than we achieved this year, that for me will be a really good success because it will have bettered again what we achieved last year. We're all the time trying to make judgments here. The Commission, when I talk to the Commission thinks it's not just this country, but the Commission thinks that all the member states are crazy with this slavish adherence to a December payment target. For them, they think the member states should be putting more effort into correctly finalising and targeting risk and managing as many checks and controls as they need to pay out to the June target. So there is this kind of self-inflicted thing that nearly all the member states have, which is about how to get farmers paid to the month that's the earliest month you can possibly pay.
But yet so many other departments and so many other member states do it so far better than we do.
I don't think that would be the case in comparison with this year. I think we have caught up an quite a lot. And I know from my last engagement with the Commission that the Commission is sending us messages now about how much we have improved and how pleased they are with that improvement, and that they would like to see other member states copying what has happened in Northern Ireland. And that is the kind of message that's now coming from the Commission very directly.
Can I ask a final question? How many inspections are carried out each year?
It varies depending on the final number of applications, and also sometimes there are adjustments in the rules around exactly
5%,
what.
yeah.
But it's in the region of 2,000 inspections per annum. It could be somewhat less this year if there are fewer applications.
So basically, we're going to be saying that 3/4 of inspections are being done with remote sensing?
It could be in that range, yeah.
Right,
But
okay.
there will still be lots and lots of visiting fields, and inspectors will still be very busy with that.
But that's the key point. When will those field inspections take place? Before
Those-
December or after December?
we would want to see those taking place before December this year.
All of them?
Yeah.
All of the inspections for those 1,000, for all of them, for the 2,000 inspections?
Yeah, that's what we want to see.
Okay. Any other members want to come in? Okay, Oliver, you're happy enough?
Thank you.
Okay. Well, again, thank you very much. Sorry for the delay and the wait in between. But again, thank you very much for remaining behind. Thank you. Okay, members.
Good questions. All the members have good questions now.
Agenda item number 7 then is the business plan 2014-2015, including an update on tree disease and oral briefing from the Forest Service. Can I refer members to the memo from the clerk at pages 244 and 246, and papers from the department at pages 247 to 271. Can I welcome to the committee Malcolm Beattie, Chief Executive, Stuart Morwood, Director of Plant Health Policy, Jim Crummy, Director of Plant Health Inspection, and Alistair McCracken, Principal Scientific Officer of AFBI. You're all very welcome to the committee as always. Now, members will already have had a chance to read your briefing paper, so can I ask you to take no more than 10 minutes? Malcolm, if you're leading off for us. Yes, I understand that you will give the committee an oral update on the tree disease also. But of course then we have the business plan 2014-2015 to deal with. Members, can I ask you to keep your questions concise and to the point, and any supplementaries questions you ask on the issue we can go around again if possible. And I would beg your indulgence, we are nearly wrapped up if we can get through this. Okay, without further ado, Malcolm, carry on, thank you.
Okay, thank you, Chairman. Don't plan to say very much about the business plan. It's there, and quite happy to take questions on that. Sets out what the Forest Service intends to do in the way of its business this year. A major change from last year, it now incorporates the Plant Health Inspection Branch and the Policy Unit. And my colleague Jim Crummy will give you a short presentation on how we intend to roll that out. And really, from that, then I think we should spend most of the briefing on the plant health bit, if you're happy with that. Jim, could you maybe say what's happening on your inspections this year?
Okay. Right, just to give you a quick introduction. Obviously, the key aim of Forest Service Plant Health Inspection Branch is to control and where possible, eradicate plant pests and diseases that occur but are not normally present in Northern Ireland. And this is across agriculture, horticulture, trees, wood and bark, and also in support of bee and bee health. We achieve this by basically the delivery of inspection programmes to monitor compliance with forestry and plant health legislation, in addition to implementation of seed certification schemes, and also, as I said, implementing legislation in support of bee health. The primary legislation, obviously, that we operate under is the Plant Health Order, Northern Ireland 2006, and seed potato regulations as amended. Basically, we'll say a little bit about, I suppose, Plant Health Inspection Branch, which has migrated from what was Service Delivery Group and is now the responsibility of Malcolm Beattie within Forest Service. We have three broad functions: implementation of legislation relating to plant health. We also provide technical support and information to Forest Service Plant Health Policy Branch and the Forest Service Operations, and we are in close liaison with authorities and across the UK Plant Health Service in Scotland, England, Wales, and with DAFM in the south of Ireland. I suppose our third function really is then the provision of technical support and guidance to plant health stakeholders in support of compliance with the legislation, and also in the development of assisting industry in the development of an all-island approach to plant health as envisaged within the agri-food strategy. The approach we adopt is that each inspectorate within Plant Health Inspection Branch will develop detailed operational plans and targets. Basically, our targets and our programmes are based on risk, and it's very much a risk-based, intelligence-led approach to targeting our inspections. Adhere to the DARD enforcement policy, and obviously that is the outworking in the event of non-compliances. Each team with very detailed operational procedures in order that our programmes are in line with the enforcement policy and with the EU statutory requirements. Basically, we have a complement of basically 229.1 FTEs. Part of our resourcing plan, having migrated from a service delivery group to within Forest Service, to look at future roles and responsibilities, and as a resourcing plan is currently under preparation at the moment, and we would hope to have documentation for that complete by the end of June in this year in support of a business case. Just to give you a quick flavour of the range of summary of team inspection targets for the 2014 year, we would be inspecting somewhere in the region about 2,500 businesses, delivering a planned inspection programme of about 9,500 inspections, drawing samples, about 5,000 samples, mainly for diagnostic support from colleagues in AFBI in support of those inspections, and contributing to about 100 surveys to the EU and to local legislator. So that basically is a quick summary of the business operational plan for agri-food inspection.
Okay, thank you, Jim.
Okay, do you want to deal with the business plan first before moving on to tree disease?
Join it all up for you at the end.
Okay, no, that's fine.
Okay, so moving on from Jim's bit about the plant health inspections and how that works through, a large part of that is very much about Callara and Ramorum. At this point, I then want to introduce Professor McCracken, who will tell you about a conference we're having next week and the role that we'll have in Callara.
On Thursday of this week, we're having the All Ireland Callara Conference. At present, there's over 130 delegates registered for that. We have lined up what I think is quite an impressive list of speakers. We have a Norwegian plant pathologist from the Norwegian Forest and Landscape Institute who is going to give us a perspective of what's happening on continental Europe. We have speakers from the Northern Ireland Environment Agency, speakers from DAFM, from Forest Research, from the University of Cambridge, from Queen's University, from Chagasan, from AFBI, covering a wide range of subjects, including the science, but also the approach that we have taken, particularly in light of the All Ireland Calaric control strategy. In the afternoon, we are breaking out into discussion groups and hope that we will raise some stimulating and interesting comments from the stakeholders of that meeting, and that happens in Dundalk on Thursday of this week.
So that takes the science that really drives our intervention on plant health. It then feeds through into to drive the policy and inform the policy. And Stuart, just want to say a little bit about that.
Recently, the Agri-Food Strategy Board's Growing for Growth initiative recommended the development of an all-Ireland approach to plant health. Recognising that we can only do this together with stakeholders, the department has met with some subgroups of the Agri-Environment Strategy Board. That's the agriculture and horticulture subgroups. we've met them now on 2 occasions, and this is the first steps to developing a stakeholder group within industry in Northern Ireland, and that particular group in the future can help with us in relation to stakeholder consultation and indeed in developing aspects of policy. We also engage with DAFM through mechanisms under the North-South Ministerial Council. So we meet DAFM in the context of the Plant Health and Pesticide Steering Group. We do that on 2 or 3 times a year, and we also have ad hoc working groups which address specific issues, and more recently they've been dealing with issues around Phytophthora ramorum and the cross-border movement of larch logs, and also have been discussing the All-Ireland Conference on Cholera.
So that all feeds, all the plant health stuff and your responsibilities there, that feeds into the Forest Service business plan itself. And page 11 of that's probably a useful summary of that. Setting out, that's where we set out our priorities, and to enhance plant health on an all-Ireland basis, to help the agri-food industry prepare for future market opportunities, economic challenges. So all of that's really the statement of the priority, and all of the work that we've heard about is addressing that. The rest of the plan then is about much more familiar forestry territory, about forest expansion, a reduced number for us this year of 100 hectares, managing the forests that already exist, and gathering evidence about those that will inform our production targets for further years. Obviously we've got an income target, and that feeds through into the key targets. We protect the forests. There was a conference last week on GB conference on red squirrel, so that's of local interest here as well. Promoting the social use of forests. We have surveys in place, household surveys and forest-based surveys to see what people want in the forest and how frequently they're used. And then work on wind farms. Should we be developing probably some of the windier parts of the country? Should that be under trees or under forest, or what's the appropriate mixture, and dealing with the issues around that. We still have some money from the Executive's Economy and Jobs Initiative, another $2 million to spend this year. Some of that's, we spent about that amount last year, and that's already giving good reaction from our visitor people that come to the forests. They see the buildings painted, they see buildings repaired, they see forest drives improved. People are reacting well to the plans for the caravan site up in the Moyle Council area, and then move our headquarters to Fermanagh. So a busy enough year.
Okay, thank you very much, Malcolm, and all the other contributors. Thank you very much. I'm going to go straight to questions. Joanne Dobson.
Thank you, Chair. Can I thank you for your briefing? My question is with regard to your business plan, and how closely do you believe the service works with organisations such as the Woodland Trust to ensure that decisions are taken and inform the views of the stakeholders in Northern Ireland? And do you believe there is scope for strategic partnership between the stakeholders and the service, as obviously you're looking to increase forestry coverage, which is your strategic aim? Can you give us an update then on how you feel you've performed in this in the last year?
We'll have another presentation later on our annual report and accounts, so assume you won't ask me the same question again then.
I'll only ask you once.
Okay. Yes, we're now an organisation that's a fraction of the size it used to be, so if we're going to deliver, we have to do that through partnerships. We've spent a lot of effort in the past year engaging with local councils, and particularly on the tourism agenda, recreation, and yeah, there's interest there. We meet organisations like the Woodland Trust, the RSPB, the Ulster Wildlife Trust. There's a stakeholders forum, and they come to me hear what their aspirations are. Quite often we find that one organisation wants this, another organisation wants something slightly different. They don't all want the same thing, and I think that's our job, is to join that up, so that if an organisation focuses primarily on growing native broadleaf trees, we say, yeah, that's fine, but that's not necessarily what all landowners want. Some landowners want a commercial crop out of this, and that features into the afforestation strategy. looking forward, we're working on the new rural development plan, and I think there are opportunities there for some of these organisations to become delivery partners, and we kind of flesh out what some of those ideas might be. For example, Ulster Wildlife Trust on Friday were explaining to me their aspiration. They might want to become our partner in managing some of our nature reserves. So can we do that? That would be a very sensible thing to do, because these organisations have a much better way of contacting with individual members of the public than we do. They're simply more present on the ground and more local. So that's something I'd welcome. I think that's got to be our job, is writing these strategies and putting the strategies into effect to make those effective. Is that the answer you're leaning towards?
Supplementary, Chair.
Yep,
So obviously you've named the Woodland Trust and others, and they do have their innovative ideas to increase the coverage. And given, as I said in my first question, increased forestry coverage will be one of your key challenges facing the service in the coming year. What more do you feel you could do to take full advantage of these initiatives and to help you achieve your aims?
One thing we have been in the new rural development programme, it's been pretty clear that the department finds it easier, or has more contact with landowners at a small scale through the agri-environment scheme. So it is likely that small woodlands will be delivered through that programme rather than through mainstream forestry grants. So if we change the interaction. I think there's still a role for the bigger plantings to come back to us and those organisations that are more comfortable with large-scale forestry. The Woodland Trust and organisations like that lie in that kind of boundary area. Yes, they can do big programmes. They are always grant aided by us. Yes, they'll have their own funds, and they will come to us for that, the capital grants that actually put the trees on the ground. And we work with them, we listen to them. We increasingly want to get to the stage where they're bringing their planting proposals to us instead of us giving them, this is what you're going to do. So the letter of offer will be much more, you tell us what you want. If we can agree it, we will do. And that's the direction.
That's great, thank you. Thanks, Chair.
Okay, William Irwin.
Thank you, Mr. Chairman. Last year, there was an additional 4 million set aside to upgrade some forest parks and caravan sites. What were you on with that, and what were you on with that, and how many forests were involved?
I don't remember the number of forests. We're about halfway through it. We spent £1.5 million. Cash out the door or accruals. We've actually committed £2.5 million out of that. So the balance of the 4 million to spend this year.
Okay.
Given that we didn't actually start things moving till about halfway through the year, I think that's okay, and I think we're on track for that.
In my own area, I know Gosford was mentioned. Has anything been done at Gosford?
Yes, there's a proposal for a children's play area, if I've got that right, in Gosford itself, so yes.
I think was an upgraded toilets that are needed, or maybe
there are certainly people who would like to do a more commercial version of Gosford. We haven't got to that stage. That may come in the future. Not out of this programme. I don't think there's time for that. In the Moyle Council area, the current Moyle Council engaged with and came forward with a very good vision for how they wanted to use forests in their council area. So they want to redevelop the caravan site at Glenariff. They want to bring in cycling in Ballypatrick. They want to do work in Ballycastle. That's the kind of thing I think is really good, because that's good engagement, good vision. We can see how they want to take it forward, because we'll not be managing these. Quite happy to put the works in place. We want somebody that's a council or another partner, it's a commercial partner even better, to come in and actually do that. It works in Castlewellan, a lot of restoration on the listed buildings there. And the greenhouses, they've been redone or finished. Can't remember if the walkway in Glenariff was done out of that money or separately, but all done. Lochnavar Forest Drive, I mentioned earlier, that's been re-tarmacked. So there's money going into quite a wide area. I know there are other, I can't remember what stage they're at, but there are also proposals in the Mid-Ulster area as well.
That's good. In relation to
this thing's really about, we need some big winners, like the Moyle, but we also need to spread this so we get good buy-in from everybody.
Yeah, and it's good that local councils will work with you in regard to that. I think that's very important, to make full advantage of.
Yes.
Yeah. In relation to Steinbach, what's the latest situation? It seems to have died down a bit, or maybe...
It's winter. Trees are not in leaf yet, so from now on we will start to see evidence whether our efforts last year have been successful or not. That's what the conference is now about, really to take this forward and say, look, what lessons have we learnt ourselves? What have we learnt from overseas? What are the likely strategies? There's a pessimistic view, and if it is so, what outcomes do we plan from that? There's an optimistic view, until maybe we were very successful last year, in which case, what's the next stage? We're at that kind of cusp until we get some evidence. We really don't know which way we're going, but we need to plan for both.
Okay, thank you.
Okay, Alderman Mullin.
Yes, thank you for your presentation. And can I first of all congratulate you on the work that you've done in Glenara Forest Park in this last year. I think you've really set that park up to be one of the jewel in the crowns for tourism, and I'm looking forward to the rest of the programme between yourselves and the council being implemented. But can I ask you, the renewable energy wind farms, and the whole ethos of that there coming through that I've read about is the real benefits to the local community on energy. Will you be having talks with the local communities on any ideas that you will have? I believe it's Mr. Haggerty, or who's in charge of that now. Will you be having any talks with local representatives or local communities on the benefits this could have to the local communities?
The answer to that is yes, but not yet. We're not at that stage. We've got plans. We say we want to develop this forest or that forest, and therefore we're not at the stage we want to talk to people because we have nothing sensible to say. We are in discussion with the, if you like, the market and the industry. There are some really important things have to be sorted out. One of them is access to grid. If we haven't got that, there isn't a proposal. And there's been a consultation document out about offshore, onshore, and access to grid around that. So we've made comments on the back of that. There's always the issue about planning. I mean, we were only prepared to put projects in that are actually going to stand up in terms of planning. So no special treatment for us. And we have got to go through all of that and work out which are the if you like, the front runners, which forests are going to come to market soonest, which ones are going to be later. And it's at that point I think we'd want to talk to the local groups. And there's already some initial discussion. Mr. Hegarty's been to various conferences that local groups are represented at, listening to what the views are. Not appropriate for them quite at this stage to say things, but certainly listening and seeing what the ideas are. So yes, we will be engaged. We will be doing this. I would stress it's not just about local communities, it's about meeting renewable targets in the 40% renewables bit. It is about keeping the lights on because we are energy deficient. So I think we have a role to play there, and we intend to be a fairly major player.
Okay. Joe Byrne.
Thanks, Chairman. I welcome the presentation. In relation to the overall strategy over the 50 years to increase the amount of forestry from 8% to 12%, is that going to be achieved all within the public sector, or does that require private sector investment as well? And is the target too ambitious or less than ambitious? Secondly, in relation to your budget for 2013-14, even though you get the 4 million extra to develop some facilities, the revenue side has been reduced, is that right? What will the net effect of that be? And lastly, what are your plans for Killera Forest Park and for Gartland Glens Forest Park?
You wouldn't have a local interest in those, would you?
Absolutely. Killera Forest, I'm very proud of it.
Okay, see if I can remember all those. The forestation strategy, it's a 50-year target. Is it achievable? The answer to that's other parts of Europe are way beyond that. Yes. So the answer to that is yes, it should be. What's keeping it up? Well, the land that we want under trees is currently under farming. And I think really until CAP settles down, that's not going to be much clearer.
But is marginal land going to be sufficient for your afforestation programme?
It depends what you want. If we followed the model in the south, we'd be certainly focusing, targeting the marginal land, and that would be for creating a timber resource for the future. The other model is that trees are really important for access for people, and that walking and all those benefits that come from active use of the countryside, that's a very different kind of ground. It's around the towns and the cities, and that's not marginal land. So that's a different thing. Now, who's going to do it? Our model at the moment is very much about private sector. We're not buying land ourselves. Haven't done since, since last century. It's only 10 years ago.
Yeah, but strategically, that is a bottleneck.
Could be, but it depends. It costs money, because if we buy that land, it's simply an injection of capital into acquiring the land. The planting of the trees is quite cheap after that, but the land is very expensive. But
you can take another supplementary within that, Malcolm. I'm sorry about this. In relation to your timber sales and the revenue you get on an annual basis, which is somewhere between 7 and 8 million, do we take it that none of that 7 or 8 million is directly going back into the capital replanting programme, or
it goes into it goes into the planting programme, but doesn't buy land.
Okay.
We use it to replace the forest we cut down. So if you like, our business plan shows a net figure for what it costs to run the organisation. The money we get from the timber offsets the costs. It does that. But there's not enough there to go and buy land. In fact, we're in a deficit situation. The deficit is because of, well, now because of plant health as well, but also on the recreation side. I think we will probably earn a bit more in the budget. Traditionally, we've always understated that a little bit because there are always other costs come in later on. We would have an option of cutting a lot more trees down, and we could certainly increase a lot more revenue short term, but it would not be there in the medium term. So the second part of this is keeping the industry alive.
So you're having a managed exercise by a budgetary constraint. Is that the issue?
No, they not so much on the budget. The primary concern is to keep enough timber flowing from the forest to keep the industry alive, to keep the sawmills turning. We earn revenue from that, but we're driven by the timber side rather than by the revenue side. We could produce more short-term money and produce more timber, but then there's a price to pay in terms of the industry. And that's one of the strategic things we have to deal with this year. There were other questions. Gortin,
Killeder, and also, yes, sorry. That was it.
Okay. We have been speaking to Chief Executive in OMA and is still Strabane? Danny, whatever.
Yes, Strabane still exists on the map, yeah.
Yes, okay. Yes, we'd be very keen that the council there would come on as a partner. I can't remember, is there a part of the 4 million invested in that? I just can't remember that. But the 4 million doesn't deal with all the issues we found. When we talk to everybody, we find there's a wish list for 14 million. So, yeah, we could do a lot more. I'm sure the business case would stack up for some of that. The 4 million really is saying, look, let's address some of the problems we've encountered in the past, and that's where we are.
It's just general. We did have a very good Garton Glen Forest Park in the past, but it has become somewhat dilapidated in the.
I agree.
Facilities for the.
Yes, we'd like to do it.
Yeah.
So the sort of thing we did at Lochnavar, it'd be nice to do the same at Gortin and replace the tarmac drive and stuff. I can't remember if we've done work or not.
Thank you, Chairman.
Just with regards to the overall programme for government target for the executive, I think it's double from 8. Some people argue it was 6. Then you found the other 2% from somewhere, up to 12%. You're going to need a game changer somewhere along the line.
Yes.
Because annual business plans don't reflect or mirror that ambition. Give me any idea. I know CAP's a big elephant in the room, but for me, CAP will only send it the wrong way, a negative way as opposed to a positive way. So looking beyond CAP and what that may bring, where do you see the game changers in years to come?
Well, if we're going for forests which are about creating a timber industry, that is CAP, because it's one use of land to produce trees or food, and there shouldn't be any arguments, CAP or forestry. The other game changer, which is the one I think we will have to come to terms with, is the public access, and particularly the health side. There's evidence from GB that if people have access to the countryside, they're in better health than they used to be. And some evidence that we don't have enough places around our towns and cities to actually go and enjoy the countryside. Some of that, I think, should be trees. That's what people tell us they like. That would be the game changer, but it is an expensive game changer. It means buying or bringing that land. Well, I can't imagine that the current private owners would want the public walking over their land. That's the kind of game changer need to happen. Now, I haven't written the business case for that. It might or might not stack up, but that's, I think, where we probably need to go.
And are you basically talking about brownfield sites?
No,
They're
we don't
like
have
factories.
We don't have those here. In England, a lot of that kind of afforestation happened in the coal mines and those kind of big industrial areas. We never had that in Northern Ireland. So we're looking at really those farms that are up against the small villages. Beaver Park, we have because it was housing executive, and then a bit of it came to the department. But that's an immensely important forest for Belfast. People use that every day. You see all sorts of people there. Young people you see on their bicycles, you see people my age, people much older. And that's all good and out enjoying it, but taking exercise in a nice place. That feeds in, of course, into the Lagan Valley Park, and that's, we're part of it, we're not the whole thing. You would see the same thing in Hillsborough. An accident, the town grew up around it, but very important lessons to learn there. Our strategy in the 60s and 70s was very much about creating forest parks. You drove from the town to those places. But the need now is for somewhere you can walk out your door and 10 minutes later you're having a walk. You're enjoying it. You shouldn't have to get in your car to go a place, because you'll not take that exercise often enough.
Okay, with regards to the actual tree, plant health and tree disease and the battles you're fighting currently, and I understand the question and the answers you give with regards to the winter. But there was to be an administrative process with the Republic of Ireland. The last time you were here, we got a very mute answer with regards to the specific question of was the Republic of Ireland holding us up or back, considering the legislation that was put forward in GB to tackle high-risk species. Where are we at with that? Or are we still being held up by the Republic of Ireland?
Well, I'm not going to use those terms. The position is unchanged, but we also said that we were going to monitor what trade there was. We said we'd access to the commercial documents. Jim, would you like to give an update of what we have discovered from using that information?
Yeah, I think in addition to the existing sort of in-country plant health inspection programs that I outlined, we've continued to implement an administrative process which complements that. Effectively, plant health inspectors identify consignments of plants and trees from other EU countries and from GB through the detailed examination of various shipping manifests at the port of entry. Are really building on that information, and based on that, and in addition, any additional information from hauliers or shipping agents, this enables inspectors then to assess the risk from that consignment. The inspector can then initiate a follow-up action at the actual point of destination for that trade. Give you just some quick figures on the benefit of that knowledge, of having that knowledge, is that it means plants can be inspected very, very soon after they've arrived at the point of destination and before they're disseminated to sort of the terminal trade. 2014 to date, I think 25% of the consignments have been followed up, with 16 from 58, and there was no findings. Now, obviously, we are looking for pine, sweet chestnut, plane, but largely a lot of those trades were containerised large landscape plants. But we were able then to inspect before they were disseminated, and so that's been quite successful, and that's for intra-EU and GB trade. We have also an additional third country imports, and basically a lot of those are for regulated trades, controlled materials, and of those I think we had 42 consignments. 33 of those were cut flowers from Dianthus and Rosa from Colombia, and then with apples from the States. They are all subject to 100% documentary checks at the port of entry, and phytosanitary certificates are checked. So they all were compliant and free from any quarantine disease or pest. So we feel the administrative process has reinforced the in-country normal programme, which I outlined very quickly earlier, and that has been quite successful.
The Minister is on record saying that she wants a legislative process. What difference would it make?
It would then give the certainty of law to this process. At the moment, we're relying on people's goodwill when you talk to people. Yes, we have a right to see some of these documents, but if people have a duty to notify us, then it changes the game a little bit. Perhaps an example might come from potato side, where there's already a requirement to pre-notify. Yeah. And Jim had a case just before Easter, which led to a very good outcome. Do you want to say something?
Yeah, I suppose they're really arising from a number of plant health issues a number of years ago. emerging threats such as the Dicea species led us to amend the plant health order to require pre-notification, certainly of potatoes for planting, and that was both from within GB and from permitted areas of Europe. So effectively that enables inspectors to target the riskier sources and to sample that prior to it being planted, and that's where we work quite closely with stakeholders. Nobody wants the interruption and the expense of having planted in advance of testing. So ideally, we pre-notification, rapid turnaround testing, and then a decision can be made if it's free from the pest, then it can be planted. And that has worked and has been embraced, I would say, by the trade. They see merit. People want to have the reputational protection, they've complied with the legislation, and they have done their bit as a shared responsibility to try and protect plant health. But as Malcolm said just before, in Good Easter and Good Friday, we had a positive finding. Compliance from the grower, he didn't plant, and so it was a satisfactory outcome.
So that begs a question then, why are we not further down the legislative process? I'm getting tired. Why are we not further down that road?
Because
it is such a good idea, and it is a very important issue regarding plant health and tree disease.
Essentially, it's because we're working within the single European market, and we do need to take the Commission with us. So the delay is really waiting for our partners in the South have asked some questions to the Commission. They're really waiting for the Commission's response. I'm not party to the question, I'm not party to the discussion.
Have we any deadlines of when they are to be answered, if at all?
I can't add to the answer, I'm afraid.
Right, okay. Maybe it'd be in order that the committee write to the Minister asking just for that information.
I don't think the Minister would be party to that information either, Chairman.
Even if she's had discussions with the relevant Minister down south.
Yes,
to see if she can throw any light on it. And if even ask the Minister then with regards to any more further delays on this legislative process, what more then can she do to progress it and or initiate legislation on her own with regards to this jurisdiction? Again, I understand the reasons why we need the two jurisdictions, but I do feel it's important to try and progress and push this aspect as much as possible. If I could change tact, issue around the wind farm, target 20, key target 20 defines the Forest Service regarding wind farm development. And again, as we progress, we seem to be getting more learned large wind farm technology and renewable technologies. One thing is coming in very, very clearly is that cost has a massive bearing, and costs increase considerably when there is no grid.
When there's no
grid.
Absolutely. Yeah.
Majority of your forests are based, not the majority, but a large swathe of your forests are based in the west, Fermanagh.
The majority.
Majority's okay. Sorry for that. The majority. So, is it going to be the case that when a business case is done for this, that you're going to stick more wind farms in more of our forests in the east of the province?
No. The attraction of the western forests for wind farms is they're very large, and that you can therefore cluster the wind farms, the turbines, so you get a large single contribution to a grid. And I think that's one of the attractiveness of that for the potential investors. I doubt very much if the department ever want to actually construct those turbines. That would be for the investors to do, and all paying for all the costs after that. So it's really, our role will be to prepare this for market, and then let the market decide how they want to engage with it. I can't see us taking this in the east at all. There are too many other considerations. Too close to housing, for one thing. The forests are much smaller. There may be one or two cases we want to do that. For example, where the grid goes past our forest, yes, it might be sensible to connect up to that, or there's a wind farm beside us. But in the main, our ambition is to go west for that.
Okay, Joanne Dobson.
Thank you, Chair. Your staff has increased from 217 last year to 254 this year. Is this due to the transfer of staff to deal with the tree disease issue? I think it was Alistair, you spoke earlier about the All Ireland Shalara Conference this week, which sounded very interesting. So what do you, is that why there's an increase in staff because of that?
It's because the Plant Health Inspector has now joined the Forest Service.
Okay.
There's no increase in the department staffing. It's just a rebrigrading.
Okay. And Malcolm, you yourself spoke earlier, you briefly touched on the new headquarters. What do you think will happen then to staff numbers as you look to the transfer later on this year, you said, to new headquarters? Can you maybe give us a brief update on the project?
Well, we've done some, we've asked our staff what they think of this, and a certain number have said yes, they're going to move, others said maybe, depends on the conditions, and quite a few said no, they're not moving. That then gives me, as the Chief Executive, some pause for thought and say, right, I have a service to deliver. What's it going to look like when I go there? Is it going to be exactly the same as it is in Belfast? Or, since we're going to incur this pain, should we actually do it differently? So that's where we are at the moment. I need to really write down what my organisational model is, how I intend to deliver forestry services, staff that appropriately. Let's see what that looks like. The target for being in there by next summer is firm. We have some information back from the properties people as to what the accommodation might be in Skene House, for example. We have to then figure out, well, there are people already there. What's that mean in terms of adding more staff in? Have we got capacity? So those are the sort of issues we need to work through.
When will you be in a position then to update the committee on the negotiations for staff?
These things always take longer than I hope.
Given you intend to be there next summer?
I intended to have my plans done by now, and I haven't got there. I think by the autumn, certainly I need to be very clear, because at that point we have to start construction works. There's a refurbishment programme that takes time. If we're going to achieve next summer, we need plans pretty firm by the autumn. The early autumn.
Optimistic. Finally, Chair, just a project manager was appointed last year, and what tasks have been completed so far, and are these on track to be completed by this summer?
We appointed him, and then he was absorbed into the department's relocation team. So he actually works directly to that team. Now, I'm still I still own the project, but the kind of work he's been doing is with the department. So they've done the quality impact assessment, started pretty well through the business case, getting the information on costings into that. They're waiting now for me to write my operational delivery model for them, and then we're pretty well there at sending this off for approvals.
Okay.
So,
that's great.
a lot of work
Thank
done.
you. Thanks, Chair.
Okay. With regards to the photographs, the policy in Republic with regards to the outbreak in County Leitrim, that you showed us
last time.
I don't like using this term, but the erratic, basically the widespread
scorched earth
policy, basically. There's no other nice way of putting it without trying to alarm the population. Is there any more outbreaks like that? Did that work efficiently, effectively?
The answer is we won't know until we start to see the ash trees in that area come into leaf. It's really important that we and our colleagues South start to monitor or keep on monitoring around these outbreak areas. As the trees come into leaf, that'll tell the story.
Right, okay.
So now on is really important. We learned something at the conference. How much we learn, well, we'll just have to wait and see.
Mm-hmm. We've seen the mobilisation basically of your department last year in dealing with this. Are we ready for it again once trees come onto leaf, once we can sort of measure the extent of the problem?
Yes.
Are we in a position to do that?
That's Jim's business plan.
Yeah, okay.
Yeah, I think maybe just we have a fairly detailed Calara surveillance plan for 2014, and this will involve estimating roughly 1,000 surveys. It'll be based on a proactive surveillance programme, which will be really prioritising, going back to trace sites that were inspected in 2013, where Calara wasn't detected. During that survey year, there was no destruction action taken, but given that those sites were linked to infected material and potential issue of latency, that the disease didn't actually express itself, those sites will be re-inspected in 2014, and that'll be supplemented by a programme of buffer surveys, again around 2013 outbreak sites, with the aim of that, Chair, will be trying to detect the spread of any disease from recently planted ash into the surrounding environment. They'll be carried out up to a 500-metre radius from the site that was destroyed in 2013. So that'll look at the original destruction sites, hedgerows that contain ash, especially those in close proximity to the destruction site, and any recently planted ash trees, any naturally regenerated ash, and also mature ash trees. And then that'll be supplemented then by a structured 10-kilometre grid survey, 10 square kilometre grid survey. Getting tired myself. And there's 184 10-kilometre square grid squares, and all ash trees within a 50-mile radius of a fixed point within those will be surveyed.
And of course,
that's in addition then to the reactive surveillance, which will be generated over the life of the 2014 surveillance plan. Again, there'll be trace exercises. Again, stakeholder leads, very important. We get a lot of stakeholder leads, and then buffers on any new outbreak sites that come to light in 2014. So I think once the season materialises, we have a programme in place, and we have the resource there to deliver that.
On the other side of that, then Remorum is still there.
Yeah.
Another 350 odd hectares to fell this year. We've already done 700. We've now experienced that the private sector are starting to come to terms with how to get their timber into market, working with them. So there's a lot of work on our own account, bringing people with us and helping them through that.
Okay, no further questions. Thank you very much, gentlemen, for your presence here today and your presentation and answers. Thank you. Thank you very much for keeping you also. Okay, members, moving on then. We are, if you can indulge me, just we are very near the end here. You'll be glad to know. Agenda item number 8 is correspondence. Can I refer members to correspondence received at pages 274 to 292? Are members content to extra correspondence as suggested in the index sheet at 273?
Agreed.
Agreed, yep.
Agreed. Okay. Very quick there. You obviously have read that thoroughly. Agenda item number 9 is forward work programme. Can I refer members to the forward work programme pages 294 to 297? Can I seek agreement for the forward work programme? Given the fact now that as we've paced ourselves, we may well need, in fact we will need an additional meeting to deal specifically with the rest of the clauses of the reservoir bill. Are members content?
Great.
Chairman.
Okay. Agenda item number 10 is any other business? Is there any other business?
Chairman, can I just raise an issue? There was a councillor from South Down contacted me about finding dead sheep and lambs, but the issue that they've raised is this charge of £24 to be paid for a ewe that has to be removed, if it dies on a farm and has to be removed, or £80 for the cattle that has to be removed. Now, I'm just noting it, and also we had a case in the last week in the Other area of South Road where 20 plus calves were found dead.
Yes.
So maybe if we could write a letter to the Minister or something just to inquire about that issue.
There is another issue on it. It's based up in East Londonderry, whereby there was a landowner who lived in GB who came over to live and found someone was actually using their land to herd cattle, and some of those had died also, and it was left to the landowner to remove them and the cost associated with that.
There's a case in Carrickfergus there yesterday. Calves and sheep dumped at the waterworks.
So again, there is a pattern forming. Now there is another issue in the Dungannon area along with regards to horses.
Yes.
Again, not a farm animal, different jurisdiction, but I know Dard were involved in that also, and that was highly publicised in the local press and the Sunday papers since I think February.
When I raised with the Minister, and she said the matter had been dealt with, so I took that at face value.
The matter seems to have been dealt with by the fact that Dard seems to have buried the animals on the ground, and they had got special dispensation from Europe on that. But people are telling me now that those where those animals' carcasses were buried inappropriately, inadequately, and close to watercourses. So again, I've only received today further information on this, but again, I think it's the overall trend whereby animals of all nature, types and stock are being left to rot and be neglected.
I understood in public property it was a local council's problem. Well, it used to be, well, it's changed. I understood that it was the local council's problem if it was.
Yeah, I think a lot of these incidents, they're actually on land that somebody owns, but who don't necessarily own the animals.
They're on private land, usually, maybe the owner isn't clearly identifiable, but local people are concerned about the decay of these carcasses, so it's left with somebody to try and deal with.
So if I write to start asking them to how it's dealing with the actual situations that you've mentioned, what it's doing to prevent these kind of situations happening, and what has been done to ensure that when animals are buried, they're buried in the correct manner with no danger to watercourses.
And I would tie this up with the greater scheme, which is the Welfare of Animals Bill, and whether it is actually working, whether it is fit for purpose, and whether the fears of some members at that time were whereby councils and other officials and other have the capacity and the expertise to actually deal with it.
I suspect, and I don't know the issue, but I suspect the only reason they may have been buried would be that they were badly decomposed and could no longer go to a rendering plant, and that's probably...
I suspect so.
Yeah, I suspect so, because normal practice is to go to a rendering plant.
Yeah, the horses were there.
Okay.
Okay.
I think it's more and more difficult for farmers to dump animals, large animals anyway, because I mean you have to identify where those animals go to if they're in your herd. What is happening, I suspect, is young calves and things before they're tagged.
Yeah. Okay, any other further business? No. Okay, date and time of next meeting will be Tuesday, 13th of May 2014 at 1:30 p.m. and 1:30 Parliament Buildings. I declare the meeting adjourned.